Seem presumptuous.
Are you sure?
That email that you sent me,
Yeah.
the correspondence with,
Yeah.
he said he sent you an attachment because I couldn't follow whose was what comments. I didn't get any attachment, what else I got was,
Oh, I don't think that was just up from our zoning ordinance though. That was,
No.
this was one about, what, 4:30, 5 o'clock today?
No, it was earlier than that.
That one.
Yeah. You're right, I forgot to forward the attachment.
Yeah, he said something about an attachment, and I hate the way Gmail does this, I'm trying to figure out which one's first.
Well, that looks like that's in order. But I'll show you and get that to you.
Yeah, there's this one, and then that's your.
Yeah, so, what I.
Attached is a handout from Steve and Dan, I didn't, that's what I did.
Yep. Oops, there's obviously a couple of extracts from it there and all that.
Yeah.
Who sent that?
Goofed.
Is that for today's
No,
meeting?
no.
Oh, okay.
No, stuff for the county.
Oh, geez, who cares about them?
I'll let them know you said that. Mr. Stickles said.
Who cares about the county?
Alright, so he walks back
I'm
in.
right on the, my house is right on the county line, so if they give me too much trouble, I'll annex to Tennessee.
Annex, you move.
No, I'll figure out a way to get my property, I'm just kidding. Could be in Fenton
Alright,
Township.
here he comes. Oh, that would be interesting. Alright. You all set over there, chief?
I am.
You can stay standing there.
Can I? All right.
Yeah. Let's start the meeting. Please rise for the Pledge of Allegiance.
I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, welcome everybody. Next item on the agenda is call to the public. Anybody here for questions, comments, concerns not related to an agenda item? If it's an agenda item, we'll let you be heard and talk to you when we get to that point on the agenda. Anybody with anything else? Okay, hearing none. Approval of the agenda. Motion and a second to approve the agenda as presented. Any further discussion? All in favor, please say aye.
Aye.
Anybody opposed? Motion carries. Next up would be minutes from November 12th. So let's work through page 1. Hearing nothing, page 2. That thing is dropping out over there. This one's working, so that's gotta be wireless. That's, that should be, doesn't mean
touch
data.
your key? Does it look like as soon as you put your finger on it, that thing will go?
Well, it looks almost.
Just saying.
Yeah, I don't know if it's going to sleep or if it's timing out, or I mean, if it's losing data, but I mean, it's not through. But anything on page 2? Okay, page 3. I hit one extra word at the bottom on line 138. Anybody catch anything else?
Move to approve the minutes from the November 12th meeting.
Motion and a second to approve the November 12th, 2019 minutes as presented. Any further discussion? All in favor, please say aye.
Aye.
Anybody opposed? Motion carries. Alright, so that is,
We might ask what the audience member in there for.
sure.
Okay, What's everybody here for tonight?
Runyon Lake Road new bill.
Okay, anybody here for any other topics? Okay,
I'll make a motion, we suspend the order of business, put new business items 1 and 2 in front of old business.
Support.
okay, motion and a second to suspend the order of business. Any further discussion? All in favor, please say aye.
Aye.
Anybody opposed? Motion carries. All right, so we will jump right away to new business number 1. Let's see here, I think this is it. And let's see, did we have, what else did we have? Okay, that's something else. We have, yeah, so this was the attempt to draw lines. Okay, so that's for us. All right, so I think the best way to begin this is, Mr. Bentley, would you be kind enough to give everybody an overview of your project, please?
Basically, my proposed project is to build a ranch with a walkout basement into my hill. I mean, and keep my proposed, or my existing structure to live in while I'm building.
Okay. All right. And then, let's see here, this diagram here. So we've done some preliminary work to try to begin to assess sightline impacts or potential sightline impacts. So this one's a blob, you can't really see, but this was, just to get everybody on the same page, this was an attempt to establish a reference point. So let me actually go to the bottom of this documentation here to get some idea of how this was established. So here's a view, so the site that Mr. Bentley is talking about developing is right here. So out here you can see the island on Runyon Lake. So using that as a reference point, Mr. Bentley provided a rendering that attempts to show where the home would be located and the elevation, so that the impact to sightlines can be further assessed. And so you can see again that this would still allow you to effectively see the island. So just to get a preliminary sense of what that impact might be based on that information. So a line was drawn from that same perspective, which is the corner of the adjacent neighbor to the north's home. That line extends out. For those of you familiar, this is the island. This surrounded is a sandbar. So this line extends out approximately as shown in that rendering. And then just zooming in a little bit more, you can see again the location of the line, adjacent neighbor, going up towards the island. Now, to convince you that's the island, this is a Google map, and you can see how the line bisects the letter R. So, oops, wrong way. So if I go back up here to this view pulled way up, you can see it still bisects the letter R. So that's a fixed point. So again, we're bisecting the letter R. And then this would be a close-up with that same line extended. So again, here's the corner of the adjacent property. This is a rough approximation of the footprint of the proposed home. And this line, this black line here is the line that would extend back out again to the R out there by the island. And then this line here, since we didn't have a perspective of this side, we just went ahead and drew a line off, clipping the corner of the proposed structure to say that would be the absolute worst case scenario. Not that that situation exists, but that would be the worst case if that was an obstruction. And then trying to put some perspective here with the adjacent neighbor's home, with the approximate sight lines are there to get some sort of angular approximation of what's afforded to the adjacent neighbors. So that's a rough way to begin to assess sightline impacts. And then we typically rely on conversations between the applicant and the adjacent neighbors to kind of share what the development plan is, and hopefully a rendering of some sort, some information where everybody can kind of get on the same page relative to, hey, this is what I'm proposing, here's what's gonna be next to you, and try to get everybody as much as possible on the same page relative to what that impact, if any, is going to be to them. So, and to the best of your knowledge, Mark, that reasonably represents.
Yeah, basically I took 100, on the left side, I took 100 feet, did 2 stakes. And basically we had Photoshop in that picture from the architectural software, and basically placed that corner on that 100-foot stake, which basically gave you the length of the house proposed. Like that side, basically, it's not gonna be 100 feet long, but if you include the back corner of that garage, it's 100 feet. So
Okay.
it's just a point of reference.
Yep, which is at this point is a reasonable way of trying to
I
represent.
mean, it's still it's probably 120, 130 feet from the lake. So, I mean, I know the setbacks are 50 from the lake, but trying to keep it underneath, it's not any higher than the hill, basically, the ranch. So, as far as the elevation.
Okay. All right. So that is what we know thus far. Before we
Do you have the rendering from the lake, or?
rendering from the lake.
Yeah, I guess that one that showed it from the lake view. Maybe you don't have it, or maybe it doesn't matter.
Is that the one that had the trees and after, before and after?
Maybe. I did an architectural, markup of from the lake too, so, just kinda showing the elevations on the hill, but.
Okay. Yeah, I don't recall that. I can take a
I can
look.
find it and
Okay,
forward it.
yeah, that might help. All right, we'll give Ross a minute to do that.
I can probably email it to you right now.
Yeah, that'd be great.
Let's see here. I can do some digging, get out of
You
there.
want me to send it to you, Ross, or
Well, if you have it on your phone, you can actually just send it.
to who?
Well, you can send it to me. I'll forward it. I think I can forward it from my phone.
You know, send it to me.
Let's see here. No, no, no. So that is that, no. Let's see what we got here.
You get it?
No.
Not yet.
All right, so let's see here. Does that look like it, Mark?
Well, that was when I bought it. There you go. I think we just go back one.
There we go.
Yeah.
All right. Ah, it's paging every time I touch it. All right. All right, so that gets another perspective. So we've got that, and maybe those are the best views. I guess before we take any questions or comments from the public, any other questions or comments from the planning commission?
No, I think we're all out, probably.
All right. So this isn't a public hearing, but we always want to hear from people that have questions, comments, concerns. So to help us just document everything, please, if you want to make a comment or ask questions, just let us know who you are so we can document that for the record. And then we'll do our best to either have the applicant or us answer the question if we can. So who would like to go first?
You want me to go first then? I don't know how to do this exactly. I'm gonna try. So, I think the easiest thing for me, I worked so hard on trying to devise a letter, but I also have some pictures that concern me. And that elevation does not look like it's the same as here. Oh, I'm sorry, I'm Penny Lucia, and I am the daughter of Robert Landers, one of his daughters, that owns the property adjacent to the north side.
So you would be here?
Yes.
Okay.
Yes. And we have that one, I think. So let me just read my father's statement on this. And we did not see this picture, but we saw the other picture where it runs
So-
alongside.
That one there, or?
No,
No, it's like-
photograph
so
where he
this one would be-
superimposed the home.
Yeah.
That one.
Okay,
That's taken, deck is taken from the corner of that picture's taken from the corner of my father's property. And, that's his highest level of sight. And we're right next door to, how do you say your name?
Mark.
Mark's.
You can say Mark.
Okay, Mark's, present home that he's
Okay.
built. And, so that certainly, we use the island as our measure as well. And, the house as we see it is blocking 3/4 of the lake that we presently can see. Because of its height mostly, I
okay.
would think. So my dad, says he is the proud owner of 10476 Runyon Lake Road and the adjacent neighbor to the north of the above-mentioned construction site is what he's deeply concerned about. He says it will take at least 3/4 of the present placement, if it is presently placed and you approve it, he will lose 3/4 of his line of sight of the lake. Because he can see, if I have a picture of that. Here, I have one for each of you. Can I approach and give you a
Absolutely,
copy?
absolutely.
The view he has.
So-
And you can kind of see where that little island is. Where is it? You can barely see it. There is where it stops. So he loses out of that.
Thank you.
Thank you.
You got one?
I just paged it down so I could pull out to you the view perspective. Which one would you like?
And that's from the highest point of view that my father has. He has a walkout area, and you can see just above the, where the snow is and where the trellis begins, there's a flat area of about 40 to 50 feet that he can walk out of when he walks out of his lower level. So he wouldn't have any view from that site, basically. You know, it would be maybe close to what he has right now, but that's quite a ways down from the deck. So it would even infringe more on his view. So he says he's been privileged to have his home on his parcel that gives a much desired view. And Mr. Begley has that same view right now, as do the neighbors on the south side of him. He says, I was able to build a storage unit into the hill in front of my house that is closer to the lake, and it does not obstruct any view, including ours. You can see right over it, and we don't.
So you're talking about this right here?
Yes.
Okay.
Mhm. It actually looks like it's part of the hill. And the neighbors, the Andersons and the Pereiras, I believe they're here today, they took into consideration when they did their new builds, not to infringe on the adjacent neighbors' line of sight. We are trusting that the Beatleys will consider the effect their dream home will have on their adjacent neighbors' properties, as well as the other neighbors did. My dad says, I look forward to the improvement they want to make, but of course, I need to protect the investment I made for my family almost 50 years ago. I trust the township will seriously consider my concerns and help Mr. Beakley adjust his plans for all concerned so my family can continue to enjoy this property for many years. And this happens to be, I don't have all the copies, but this is the view from inside of my dad's house looking through the door wall. So he still has a nice significant view, almost as if he was standing on the corner of the deck.
Yeah.
So that's inside the house, which he and my mother loved, sitting in their dining room inside that door well for almost 50 years. So I'm going to read mine too. And these are, I don't know if this photograph will have any meaning, but I'm going to be referencing this zoning ordinance that you already have put in place. And this is where I think it might address our concerns.
Thank you.
Yay. Let's see. There we go. There's a lot of personal emotion involved. Like I said, it's been over almost 50 years. And because I'm nervous, I'm going to read what I wrote. I'm Penny Lucia, one of Robert Lander's daughters, and I'm here to represent him. And due to my father's age, he's 90, and his current lack of mobility, he's not able to attend this evening's meeting. And may I state that this family has had many wonderful times together on this property. We are a large family of 9 siblings, and of course we have grown in numbers and have always been grateful to come to our parents' home to enjoy the boating, skiing, swimming, etc. And the annual family reunions, bringing together all of our extended family members, is one of our very fondest memories. This property is in a family trust, and we are planning to continue enjoying and using it for many more years to come. I am glad to discover that the Planning Commission has chosen to protect property owners under zoning ordinance number 36 that I gave you. And I have, and I've already given you the pictures as well. I think I have one Oh, here we go. Do I have enough of the land layout so you can understand what we're talking about? So this is my dad's home. This is Mr. Beatley's home. And this is Mr. Anderson's home, and this is the Pereira's home, and that's from the water looking up. So that you can see where all that is. And I think that's all I had with those two, sorry.
That's-
You'll have to pass them down.
Yep, we can share.
Okay, so I'm not. Just to make it a little more clear how it's outlined.
Here's another one.
Okay. So, what did she say there? Anderson.
And I state the same thing that my father did, that, we took into consideration our neighbors, when that was built in, and we are, hoping, it's hard to tell the elevation. From here, it looks higher than when you showed us the picture from the lake. But even that, you can see that that is pretty high. It's almost as high as the neighbor to the south. And, so I think, I think it could maybe, I don't know about all of that, but it seems to me that if you could back it up,
I can tell you that the first floor, the top of the first floor, the ranch level is lower than Dave Anderson's, basement.
it doesn't look that way,
It is, trust me.
you know? It doesn't look that way from either side.
I mean, my house is lower than his basement.
So just to clarify, what you're saying, Mark, is that this level right here
Correct.
is at the same level as this or below?
It's
slightly
lower,
below?
it's lower than that.
Okay,
The floor,
But what about the top
No,
level?
the ceiling is lower.
yeah, so you're saying this
Yes.
line right here
Yes.
is less than that line right there?
Absolutely.
Okay.
Because the top of my ranch level is actually the top of my hill. So,
It doesn't, I mean, I don't know how, do you have the actual elevation?
yes, I did, I mean, I said elevations, we came out there with a laser and I ran, it's a 22-foot hill. So basically, the bottom of that 22-foot hole, or hill, is the bottom of my basement. Okay, then it's a 10-foot rise and then another 10-foot rise. So I'm still lower than the top of that hill.
Well, the top of the hill, on our hill, and I think we're both at the
Yeah,
same height,
We're right about the same height,
you
you're
can see
right.
where it is. It's the garage.
Why is it obstructed?
So why, how, yeah, if you're really saying it's as low as you say it is, why does it look so much higher? I mean,
It's not. So basically, okay, for a 10-foot basement, the top of my basement would be maybe a little higher than your garage.
What?
To the top of your ceiling, not to the top of the roof.
Yes, exactly.
Yeah, so
Well-
technically, he's going to the roof, to the ceiling, not to the peak of the roof.
Okay, so again,
Okay.
that's just
So
to,
you got your sight line is raised another 15 foot with the peak of your roof.
Yeah.
Well, so I got 20 foot of house,
I mean,
okay, and then my peak, 612 peak.
well, we're asking that you consider your adjacent neighbors, and I believe that your
I mean, I
ordinance
am.
36 does address that that's what he should be doing. But it is very obvious by your photograph that that garage is the top of our hill. You can see in the photographs where you can see my father's garage, looking out over the top of his garage is basically the top of the hill. It almost looks like the garage is built into the hill. Your home is not built into your hill. Your home rises above your hill
Another 20 feet.
by quite a bit. I
And I'm
mean,
not gonna sit here and argue with you about it's not, though.
But
I mean,
why
I'm
did-
building it into the hill.
Look at how, I mean, okay. I
Look,
don't
show the
know.
other picture, Mark, I mean,
Okay.
well,
this
so
one
let's,
is the one
so-
we need to
so
show.
let's just try to clarify here, let's go one step at a time to try to get everybody on the same page.
Adjacent.
So, I think what I heard is that this elevation here, so this ceiling,
Correct.
which we're saying is 10 foot,
Correct.
but it's the lower level, let's just classify that. You're
Basement.
saying is at the same height as this.
Right.
It's gonna be roughly, yeah, exactly.
Okay, so this here represents approximately the, I'm gonna call it the top of the hill, although the hill kind of varies and kind of
Right.
goes up a little bit in this direction here. So that means that this here would be arguably at the same level as this here,
Right.
right?
Right.
Because we're gonna be 10 foot, then we're gonna go 10
Right.
foot, so
Right.
single story.
Right.
And then you've got your roof
Correct.
on top of that, which at 612 in width must be, wait a minute, so instead of guessing here, it's on a dimension here, isn't it?
Yeah,
Let's see, I thought it was anyway.
Well,
No, there we go, okay. So from this point here, let's see, we gotta blow this up a little bit. Okay, so this is the portion we're looking at relative to the other homes, wrong direction, so we would say this is right here. So we've got 8.3, and doing the math there, so you got 4.6, if I add those three. And then you've got,
You're at 22 feet, right? 22, if you run that line over to that peak, because that back peak is the garage, that has nothing to do with that peak. That's up the hill.
yeah, so this is really, so this is really the one there. So
That one in the
you've got-
back really doesn't come into play at all.
Yeah, because it's far enough back.
Mm-hmm.
So you got 8.4 and 4.6, so you got 13 feet.
Well, I guess that's what we would ask, that he move it back. That he move it back so that it isn't obstructing view. He's in front of our garage, if you wanna call it.
we're gonna be staring down at the entrance of his house from our deck.
Yeah.
Well, you've already seen the view from basically once the house is there. I mean, where's the tree, are we bringing into the trees at all, or we're not even talking about that? That I cut down, the black walnuts that I cut down.
Oh, those.
Those trees were saplings when I was younger.
Yeah.
Okay, well, they
grew
weren't
within
when
the
I cut
last
them
few
down,
months. Let's see if I
so.
have a picture of that.
They didn't really do much.
I mean, I even talked to you before, and you said there was willow trees and all kinds of stuff that obstructing view. Now it's
That's
a
why they
total
took them
sad
down.
story, like
They got.
you
pictures.
guys use this property all the time, you're never there.
Be realistic.
I am
You're blocking the half the view of the lake, dude.
Hold on,
Well,
hey,
did you do?
Hold on, hold on.
saw the view.
come on, we got, I understand, now I understand, we've got some concerns. Let's
The view of
try to
These
be,
were the
let's
existing
just
trees.
try to be civil here as best we can and have a conversation, because shouting back and
He put
forth
trees in.
isn't gonna solve anything.
These are the trees he superimposed.
So-
Those were the actual
Let's
trees.
try to get,
that
everybody
took
try to
from
get a clear understanding
the
of
family.
what the situation is, which is what I think we're trying
So
to
it's
do.
hard to tell because
Let's
that's-
voice concerns as you have
Is
them,
it on the back side? No, it's not.
and then the planning commission can try to render a decision.
Probably got a better picture of the trees. But the trees, you can see through them. Oh, there they are. Those are the real existing trees back in the day. And those are the ones that he cut down. So the ones that he superimposed in that picture are not the real trees. Those are the real trees.
I mean, I have the pictures from the lake, I mean, they're basically the same thing I photoshopped in there. Do you have that picture?
Yeah, I have a picture that he photoshopped, but I have
I'm
a
not talking
picture
about the Photoshop picture, I'm talking about the real picture
of the trees before
from the
they.
lake. Yes.
Show the,
Show them, I mean, I've submitted them.
show the one I took from the lake.
I
Let's
just,
see, not that one. Is it this one? versus an actual.
That's not actual, that's a rendering. That's a photo being superimposed on it.
Oh, okay.
And that's
That
what
would-
with that one.
I'm using that as a
That's
reference.
one of them.
The trees block out, do you
There's no
we can see over
comparison.
the trees
Trees can be
forever,
cut down.
so.
These ones right here.
I guess I'm not sure why trees would be even considered in line of sight.
Yeah.
I don't know if I've seen that or not.
And I've sent it to Ross.
Okay.
So, I mean, there's quite a few pictures actually, right here.
Okay.
Anybody else wanna see that?
So is that a rendering with the
No,
trees,
that's
or
the
those
actual,
are the actual
that's the
trees?
actual picture from the lake.
Okay.
When did trees become structures?
No one's suggesting they are, just
Okay.
trying to get
Okay,
everybody's perspective.
okay. I think, I stated my immediate concerns. There's other things, but I think that there's ordinances in place for those kinds of things, and we'll see what happens. And then when and if this gets adjusted.
Thank you.
Thank you for your time.
Who'd like to go next? Anybody?
Hello.
Okay.
Hi, my name's Kathleen Anderson. My husband Dave and I live in a house to the south of Mr. Bentley's.
So you are this one here.
That's correct.
Okay.
And that's 10460 Reming Lake Road. Our family has owned the property we live on for the last 67 years. Yes. There's the old picture that's on the website, your website, has a little cottage across from the point. That's my husband's grandmother's cottage.
So you're talking about, let me see here, those Google Maps, right? So I think that's, let's see. This one here you're talking about? Or you said
I'm sorry, where's your
website.
cursor?
You said website.
Oh, you're the Tyrone Township website
Oh.
has a cool, a cool picture of our
Okay,
old
gotcha.
cottage. Anyway, that's not important.
Sorry.
So we have we built our home in 2014, and we have a vested interest in maintaining the existing sight lines to the lake, as do the landers. We want to be clear, we encourage Mr. Bentley to improve his property. But not at the cost of others losing their sight lines to the lake. It's one of the big draws of living on the lake, right? We are concerned that the proposed drawings and location of the house and the two-story garage will impede the sight line significantly, which could have a profound negative impact on our property value. We understand lake lots are complicated and very tricky for the township. We have also been told by Ross that there are future plans for the township to revise the ordinance to make the setbacks and sightlines on lake properties more of a priority. But that, is not the case right now. We unfortunately do not have a good neighborly relationship with Mr. Bentley. So we have not been in communication with him. We were not made aware of his plans. We weren't given a set of these. We found out that this meeting was taking place through the landers, and so we kind of put the wheels in motion and started doing some of our own investigation. So I came to see Ross, I found out on the 4th, came to see Ross on the 6th here at the office, got a copy of all the plans that were submitted. And I'm an engineer, so of course I do a lot with ordinances and regulatory laws. So I took a look at the plans and looked at the ordinance. Of course, I think there's plan deficiencies. There's no scale on the plans. There's no preparer name on the plans.
So just, I
Maybe
apologize
that's not
for interrupting
required.
you, but, so at this point, we simply went through a preliminary
Okay.
view of this.
That's
So
all I
really,
need to
at
say.
this point, I guess the way I would phrase this is, as we're learning that there are concerns here, and as we're getting more information, that's better defining what, if any, additional information might be necessary to either confirm there's an impact or confirm there's really not.
Gotcha, fair enough. One of the things that we're concerned about is not only the line of sight, but there's also an access between our two homes. And it's been in existence since the 50s. We maintain that, and we have for decades. You know, right now, it's completely torn up by the use of Mr. Bentley and his tractor.
So just to help us understand that, so you're here,
Mhm,
and then you're saying there's an access through here?
that's correct. And the access was, see that other small gray building?
Yep, this right
there?
here.
Okay, that's the old cottage that
Mhm.
was there since the 50s. And that access was to get to that lower level.
Yeah,
So,
I recall
I don't
that.
know if I know, Mark, you understand, you know, the lake. It's a very high, point there. It's probably one of the highest points of the entire lake.
Mhm.
And there's a significant, you know, steep hill there. It's not meant for regular use, especially in the wet weather months. It gets torn up easily. It's really just meant to be there for the summer, you know, to be used in summertime. We own more of the top of that, as you can see by this photo here. We own more of the top of that access, and Mr. Bentley owns more of the bottom. He has not talked to us about,
Yeah, you guys came to, before I even owned the house, you came over and that's your main concern was that road, which, I mean, by this picture, it's kinda off, those lines aren't.
So, yeah, let me just clarify this. So this is an overview from a system that Livingston County
Right.
provides called Graphical Information System. And these are approximate, so they are typically within 3 to 5 feet of actual. Also, keep in mind, there's a camera angle here, so the lines are superimposed and they're close, they're not accurate.
Right, now you go by the survey, which I had done, they own about less than 5 feet down by the flagpole, which takes it back up towards the top. They really don't own much of the road, but that was their main concern, they wanna try to keep that like some kind of road. We're not keeping it as a road, I mean,
yeah, you've been using it quite a bit.
absolutely, cause most of it's my property, it's not your property.
That's not
You like
correct.
to claim it as your property, but it's not.
If you wanna look at our
You can look at, I got the survey too,
So,
I got the
okay,
stakes
so-
where they are, I know
Yeah.
right where they're at.
So the
Well,
only
did
way.
you have a professional survey done, or did you just have a buddy do it?
I had a survey company come out and do it, and
Well,
the
we'd
survey
like to
stakes
see
were
the survey.
there.
We'd like
I
to
mean,
see
pay
that
for
survey.
one, pay for one, it was, the stakes are there, they're done.
So just.
You act like I created some crazy survey out of the blue, like I hired one of my buddies to come out and put in stakes that were already there, they're existing.
I've never seen
So
a
just-
professional vehicle in your
Just
driveway.
let's just clarify here.
It's
as
that
best
we're
we
going
can.
into crazy land here.
So there are 2 types of surveys, right?
Correct.
So there is effectively a boundary line survey, which
Sure.
means they will attempt to locate existing stakes or monuments, and use those if they are available, or they will attempt to approximate boundary lines.
Correct, and the company that came out located stakes, they located the pins,
Okay,
the
and then there,
markers, that's all they
and if
did.
they located the pins, that's fine, that's, you know, that's typically what a full stake survey would do, is identify all 4 corners, in this case, 4 corners of the property, and either set stakes or locate stakes and verify that they are where they are supposed to be according to documents in file with the county. So the only way that boundary line questions or disputes or challenges are ever reasonably resolved is stakes that everybody agrees have been set properly, and then you draw the lines, right?
Right, everybody wants to talk about professional surveys and what, I say, I'm more than welcome, bring it on. You know, it's plain, it's cut and dry, a survey, where the stakes are. Their main concern is that I was gonna come in and I wasn't gonna share the road with them. Which, I mean, by that language, when they built that big house, they weren't even supposed to have a road anymore. Like, I know there was language about getting rid of it. Their main concern, right, even before I owned the house, was they came over and like, well, you know there's this road that's like grandfathered in. And I'm like, no, I didn't even own the house yet, and you're worried about this road.
Is this material to what we're talking about here with the planning commission?
So I
Well,
would,
obvious it is, because he
I'm
she
sure.
brought it
well,
up.
so, yes, it's been brought up, let's
Okay.
actually thank you for your comment. Let's kind of stay on track. The access, I'll call it, may have some significance to the various parties, but really this is a boundary line, or I'm sorry, a sight line discussion, so let's kind of stay focused as much as we can there. Property access issues, I understand, they may be relevant, but from a planning commission point of view, right or wrong, the only thing that we at the moment have jurisdiction over is effects to sightlines.
So, one of the other, I'm looking at your blue box here
Mhm.
where.
Which again is
super close.
just approximate,
Right.
it's
I
not
believe
accurate, but
that
it's
to be
close.
even forward, even still, because if you look at Mr. Bentley's, drawings, that blue box does not butt up to that deck, it's probably a good 10 feet off there. So I believe, yeah, he has a 97-foot setback. Currently, the setbacks for our properties are, the landers are roughly, and this was just Google Earth stab that I took at it. Landers looks like it's 232 to the lake. Currently, the Betleys are 229 feet to the lake, and they're proposing 97-foot setback. Ours is 150 something. We do have a vested interest in the sightlines. I do believe, based on the stakes that I've seen out in the yard, I'm not quite sure, exactly what those, how those are staked out, and because I've never seen a staking plan or a survey that has elevations, similar to the one that we have here for our house. I don't feel comfortable that the current site plan as it's developed shows exactly where it is on the lot. So I'd like to request that we are able to look at the survey, we're able to look at the elevations, and that that we know the elevations, so that we can add up the height of the house and the peaks, and make sure that it's not in our sightline. We know for sure this is in Lander's sightline. This area, I mean, we have several, all of us have been there over 50 years. We've never had an issue. Yes, the access is maybe not an issue here tonight with the sightlines, but it is definitely something that, we want to, it's in our best interest, both of us, to have access to the lake. And I think that access is important for emergency vehicles. There's not too many accesses that emergency vehicles could get down the lake if there was an accident.
Let's talk about the sightlines. Okay, the access, I'm not sharing access with you, get that out of your head. That's all. We're not, and this is what I get, this is the conversation I get from these guys, both of them. This is the way it was when we were here. So as a new person buying a property, that's what I got from the beginning on this piece of property. That's what I get all the
We
time.
want you to be able to build. We just want to
Okay.
maintain our sightlines.
Yeah, okay. And your sightlines won't be affected at all. You're way higher than I am as far as I'm
I
concerned.
don't believe that's the case.
Well, it is.
Well, I'd like to have proof.
I don't know, I don't know what you think you're entitled to as far as what, like I have to just, I'm not messing with your sightlines at all. You're way higher than I am. My proposed house is so much lower What am I blocking of yours?
I think your peaks are definitely.
What do you think my peak's blocking of yours? That's what I'd like to know.
Our site.
Side of what?
To the north side of the lake.
To the north side of the lake.
Yes, sir.
Okay, well, I disagree.
Let's see. So we
We don't have a shot from their side, do
No.
we are concerned, that we'd like to see what the elevations are, and we'd like to make sure that the setbacks, are met, and that, that we, according to ordinance 36X, that is maintained here for this property. If you want me to read it, I will.
Now,
Well, you guys
we've got,
probably know.
yeah, I mean,
Schedule regulations.
yeah, so what you're talking about, the schedule, the requirements for sightlines, so what you provided is what we call footnote X, which references this diagram right here, or art, relative to the current way to do a sightline assessment.
So that's all I have for tonight. My husband is traveling, so couldn't be here, but, you know, he also wrote a letter, and Careers wrote a letter as well. They live on the south side of me. So, we appreciate you taking our concerns tonight, and we hope for a peaceful resolution.
Okay, thank you. Do they have any questions for her?
Did you do a shot from her side?
I don't go on the
Rendering?
property, no.
Okay.
I refuse to. We're not
That's not
friends.
true.
Yeah,
We're
it
on
is
our
true.
property at the top.
Can we, as a point of order, can we request that anybody in the audience address the board and as opposed to each other?
That would be a fantastic idea, as a way to try to minimize conflict, so let's go ahead and respectfully request that. Let's try to keep this directed, to us as the board, so we don't have the individual conversation. Any other questions for Kathleen?
In your letter, you referenced, I believe, that you have a copy of the survey.
Yes, would you like to see it?
Yes, please.
This one's ours, not.
Is there any legal documentation anywhere that you're aware of the description of this?
I don't know that. I mean, I know we have a legal description of our property boundaries, but, you know, the access was designed for that cottage down at the bottom of the hill. And, you know, once we built at the top of the hill, we demolished that because you can't have two dwellings on a
Right.
home lot, so.
Okay. Anybody else want to say?
Okay.
You okay?
Sounds good.
Yes or no? No.
Okay, thank you.
Anything further from the table?
As far as the sidelines are concerned?
No, I mean, just
Oh.
for that particular
Okay.
set of comments. Do we have anybody else that wanted to speak?
I would.
Okay. Your name, please?
My name's Tom Landers, again, one of the 9 siblings of the family. I was just putting something together. Again, I'm one of 9 siblings and had the privilege of growing up on this beautiful piece of property located over New Lake. This property has a view, I'd say, maybe 75% of the lake from the high vantage point. One of the highest vantage points on the entire lake, I'd have to say. This view, you can't beat it. my parents chose this place when moving out of the city in '69, not only for the lake, but for the view. They've had plenty of choices in the area, considering the lakes in the area, but chose this place because of the view. Growing up here, we were fortunate to be able to have the view we had. To impede on this would be a disappointment to whomever would be the owner. The view is what would be the best value added to this property besides being on one of the most desirable lakes in the area. To have the sight line almost half the large part of the lake would be very disappointing. To be able to view most of the lake has always been a great advantage, not only to us, but to our neighbors, and a great privilege. I believe much more consideration should be taken when planning to build a house directly to the south of my father's property. I'd ask Mark, how would you feel to be the owner of my father's house and have this going on?
Again,
Don't direct it to
Yeah,
me, direct it
so-
to the planning commission.
Well, all right, I'll skip that, but
It's a fair question, but
I'd like to ask Mark, how would he feel being the owner of my father's property and the view that we have on top of that hill? To view almost the entire lake. No one else has that advantage on that lake wherever. We can see almost the entire lake in that piece. And to cut 75% of that off that's just not right. I think a look into the ordinances concerning line of sight and related items needs to be really considered. And it's like I say, thank you for your time.
thank you. Any questions for this gentleman regarding his comments?
I have some other considerations though, if I would.
Yeah, go ahead.
Thank you. From the elevation drawing plans he's got there,
So this one here?
no, he's got
So
actually,
this one, let me see here.
got some elevation drawings showing
He's talking about the
architectural
actual
drawings.
It's
The
this
actual
one
plan.
here and this one here. Get the size down a little bit.
Now he's got one with the, actual property elevations. Yeah, I mean, there's a photo that you superimposed. We're standing on our deck, looking down at the entrance of our house.
So you're talking about,
No, you had it there. But it looks like to me you're topping the top of that hill.
This one? And I have copies.
No, the architectural, that one there. You're gonna top the top of that hill and you're gonna pull your drive down. Are you cutting the top of your hill off?
Cutting the top of my hill.
I mean, the road's gotta be to the right, that red line, right?
That'll be that's the grade, the driveway coming down to that.
That's the drive in the back. Oh, that drive, your drive?
I don't know
Or
what
the
you're
existing
talking,
drive?
I don't know what you're talking
The
about.
red line, what's the red line?
That's grade.
Existing?
No, proposed grade.
Proposed grade, so where's existing grade?
Well, it's a
It
big
started
hill, it's a
that-
big 22-foot hill.
Yeah, it's way the heck up there. You topping the top of that hill, I don't understand why you
So
Top.
just let me,
Look at the back
can make
elevation.
sure if we can kind of clarify here. So,
the road would be there with his cursor
so
is.
is this the current grade right here?
what does
This
that
line
arrow
here?
say right next to your cursor? Can you read that? Zoom in on that, will it
Yeah.
clear up a little?
I mean, top of hill is basically.
Grade, so I would say that right where it says grade, the driveway is gonna be matching the road grade, and then coming down to where the garage is.
Right, it's that entry down the hill, and then, so basically my garage level, or the driveway level down below, is pretty much the level about like where your dad's walkout basement is.
That's a lot of dirt to move, dude. It's a lot of dirt.
What's the, steps there underneath the red line?
The retaining wall.
It's retaining wall. It's
Oh,
got to
that's
put
the
up
footings?
hold up.
Okay.
No, I think it was just somehow, something on the program. but we
Yeah,
had to do
yeah,
it.
that's the footings of the wall, I'm sorry.
It's not funny, there's nothing back there, it's just, I mean, there's gonna be a retaining wall along the side, because the upper, so basically where grade is right now, you go right into that top garage. And then I have to cut, basically, once the house is gone, I have to cut down to get side entry into that garage.
A good 10 feet, if not more. That's a lot of dirt. And it looks like you're building it up down by the lake in order to come off your porch, your front deck there too.
No, that's not my plan, it's basically to be right about where your garage is, down the lower level garage. I mean, we shot grade to 22 feet, I mean, basically, where I came down, so from the edge of that garage to that porch was about 40 foot. And then right now, current grade at that porch is basically 10 foot 4 inches deep on that hill. So all I have to do is cut out a little bit in the back, and then grade a road.
Basically creating a bowl in your front yard adjacent to our yard.
A bowl, I mean, I'm not creating any kind of
That's
drainage
gonna be a
issue.
big bowl right there from,
I'm not creating any kind of drainage issue for your house. All my stuff will just slope onto the side and go right down to where it's always gone down the hill. It's not like I'm creating water onto your property at all.
Okay, we can address that.
yeah, well, just consider the drain, my consideration is the drainage.
Well, you're concerned about my drainage, but it's nothing to do with your drainage.
It's all lowland down
The
there,
water's
when the
gonna come
water's
down-
high, you
The
haven't
water's
been
gonna
there
come
long
down to
enough.
my house, not your house.
We will address
Sorry.
that, okay?
I mean,
Sorry.
That's not a planning
Sorry.
commission issue.
right, it's more
No,
building
no,
permit.
we said we will address
Yeah,
that.
I'm sorry. It's just, we're arguing about,
I know, let's stop.
We would be happy to see that house moved back.
like these guys have any, they're like, oh, this is our plan, like, we get to decide what you're building on your property. That's what I'm getting a lot of, is this isn't the way it was, this is the way it's,
All right, I do have a question for you.
sure.
Looking at this picture right here, this rendering, where is the current house? Where is your?
Right behind, like 10 foot off that back.
Okay, so you're telling me that your current home then starts technically right about there?
Correct.
Okay.
Well, actually, no, there's probably more than that, because there's a 14-foot deck,
Okay,
and then probably, I'm saying anywhere from like 15 to 20 feet.
It's in that area.
so
So you're
maybe
saying
back this
Yeah,
this
maybe
far.
back in there, correct.
Back this way.
So this is all going to be completed before this structure, which isn't shown here, is going to be removed?
No, I mean, before I get final build, the house is gonna have to come down. I'm gonna keep it up as long as I can, and then until I can't keep it up anymore, it gets demolished.
Okay, because that's part of the question
Correct,
tonight here
correct.
too.
I mean, yeah, the plan is, until it doesn't make sense anymore, it's gonna have to go.
Alright.
And we may have, we'll obviously have to leave in order to get our final build and get everything the way it needs to be, but we plan on living there as long as we can.
Okay, well, I just wanted to clarify that because that's not in the rendering. So,
Right.
Thank you.
Do I see a,
In this conversation, it seems like, if I understand correctly, his existing home right now is in line with my folks. They're like right adjacent to each other, if I'm correct. And so all of his garage, his home, and everything is gonna be in front of that. How that isn't gonna affect our view is, doesn't make sense. It is, it's going to, it's just not right. When, I don't know, am I correct in assuming that when you buy a piece of property, especially on a lake, you're buying the view as well as the home? It isn't just the house. When you're buying on a lake, you're buying your view as well. And I think we have every right to protect that. And not that we want to stop a beautiful home from going up or a person's dream. I'm sure he's worked very hard, as my father did, to purchase that land. I don't wanna take any dream away from something like this, but it can be worked out. You don't need to infringe on other people's rights, if it's a right to have a view. I think it is a right to have a view. He bought this, he worked hard. We searched every Sunday, driving around looking for homes when I was a little kid. And he worked 3 jobs. I know that's all sentimental stuff to most of you, but I'm sure you all have worked very hard for what you've been able to achieve. And I think we have the right to try to protect that. Plus, we have a vested interest. This is a family home, and we plan to use it for many years to come.
Thank you. Anybody have any follow-up questions for Mr. Bentley or?
I just have one. This picture was given to us off your deck.
Mm-hmm.
Do you have one when the trees were there?
I think, did I not give that to you?
There might be one up here. There we go.
I don't think I had a lot of them.
That's the this is the superimposed one.
I mean, the trees, you know, in the wintertime, oh, here it is. I have, no, that isn't it. That's the one you cut.
I think we've got them up here.
Do you have?
Yes.
Okay.
I'd like to comment on that. We've been out there for almost 50 years. Trust me, trees come and go. I'm sure you all know that. And most of those trees he's talked about, we could see over those trees for almost forever. So,
I mean, I showed you the Google view one of the trees. They're well over Anderson's flagpole.
And they were cut down.
Correct. Which is
But
by
the
right.
home, the
Cut down
home is
trees.
permanent though. You don't go up and down.
not
We also cut down, I was tired of, I was sad when my father decided to cut down the two beautiful willow trees that were right in front of the lake on the water, because we loved climbing it. But again, it was to achieve a better.
I mean, when I bought the home, I couldn't even see the lake. I mean, these willow trees, it was like I wasn't even living on a lake. All I looked at was black walnut trees.
The willow trees have been gone for
I'm
years.
not talking about the willow trees, I'm talking about the black walnut trees that I cut down that I owned.
Well,
So pay
that was
attention.
because they were in front of.
I couldn't even see the lake.
Okay, we're getting off track again.
Yeah, the comments need to be directed up here, not to each other.
I know, they start yelling at me, I'm telling you guys.
Stop.
Stop.
Yeah,
Okay.
don't respond. That's
Okay,
the
I
best way.
You said willow, no.
And
Okay, I did.
the comments need to come up to us, not to each other, please.
Okay, planning commission. What's next? So the applicant has asked us to, well, he hasn't actually asked us, part of the requirements for submittal of a land use permit for a new build is a sightline impact assessment, which is what we are going through. So we've gone through a preliminary, and then here's the planning commission to make a decision. We've got some additional input from adjacent neighbors now. So what's our next step?
If I may, I think we have some pretty black and white language about setbacks as it concerns sightlines. Greater rear yard setback may be required by the planning commission where the established setbacks of adjacent buildings are greater than the minimum required in the zoning district. Where the average rear yard setbacks, for the adjacent buildings on either side of the proposed use is greater than the minimum required for the district, planning commission may require a rear yard setback equal to or greater than the average rear yard setbacks of the adjacent buildings to preserve sightlines to the water. I think that's pretty straightforward. And the proposal we have impacts the sightlines to the water of the adjacent structures, does it not?
Well, let me respectfully ask, we have some renderings, do we have enough information? Do we
No.
question the accuracy of the information, and is there maybe more information required to assess the impact to the south, as well as to get a better or a more accurate picture of the elevations?
What we have, there's a plot plan here that's attached to the temporary dwelling application.
Let's see here, I can pull that up. Let's see, that is this one here.
Yep, second page of that, right there. So,
Okay.
all we really have in terms of the setbacks or sightlines is right here, right to the, northeast of the proposed structure. There's an arrow that says existing dwelling, pointing to the, house. You see it?
Mm-hmm.
So that's all we really have. We don't know what the actual setbacks of that existing dwelling are. We have a setback line from the lake, but we don't know his setback of his proposed house. I guess we just don't have enough information, but it sure does look like it's, close to, it's in violation of this footnote X that we have here.
Yeah, except for if this falls under the Cove or Peninsula statute, then
Yeah,
it
I don't
becomes
I don't think it does.
Well, the one next to it is more than 40 feet different.
No.
This is the 40 feet
Okay.
between the adjacent structure that it falls into the exception. So, to me, it makes sense that you guys probably already, to have a review of it on site. So, I don't know if
I would
it
like
applies
to
at this
step further.
stage.
I personally think that given the tightness of this entire site, there should be a boundary and topographical survey with both houses located on either side. Because that's the only way we're gonna be able to solve everybody's arguments about what's sight line, what's not sight line, what's gonna be impeded, what's not gonna be impeded. I know you shot stuff out there, etc. But the only way we're gonna do this and get this ironed out is to have an independent, hire an engineering firm, hire a surveying firm, do a full boundary, do a full topo, and put your house on there with the existing grades, obviously from the topo, and the proposed grades that you're gonna have with your house. That will help iron out the sightline issue, that will help iron out the concerns of the neighbors regarding grading, where that driveway's coming down. Everything will be resolved with one drawing. And I know you probably don't wanna do that, but you did make the statement, survey, bring it on. So
Well, I mean, I gotta get a survey, I gotta get staked when I build it. You know, everybody wants to throw this, like I did some petty survey out there. The stakes are in there. I didn't place stakes in there.
We're not really making that claim, but we do need to see, I think, Dave,
Well,
we do need to see a site plan that shows numbers, that shows us exactly what you're proposing, it shows us where it sits in relation to the adjacent structures, so we can't, because, like you pointed out, the
This was
adjacent
a
structures.
sightline rendering, which, I mean, I think it was pretty accurate on the sightline that was from their deck. So I don't know, what it really comes down to is, so how much do I have to, do I have to open up the whole lake to them? Like, do they have to see basically 360 degrees or 180 to see the whole lake? Where's my responsibility end as far as, where does it end, is my question.
right now, your responsibility ends in proving to us what the actual sight line is, and I'm not.
You're
sold.
not convinced by the picture showing
No.
that sight line going across?
No. I'm not trying to disrespect you or
Well, I'm
anything, I'm just
just,
saying,
I'm
I'm not
asking, like,
convinced.
what more are you expecting out of that survey besides me spending a bunch more money on basically coming up with the same thing? Because that's what you're looking for that sight line, right? Their
I'm not
sight line
certain
from
you're
their
gonna come
house.
up with the same thing, because there's certain things of it that when you try to Photoshop architectural software, that you're just not going to get a true representation of what's out there.
Okay, so let's say I do it, I spend the money, and it's basically the same thing, then what?
If it's basically the same thing, then we'll take a look at it. But until I see it, I'm just not convinced.
Well, I mean, I don't wanna spend the money if you're just gonna shoot it down and it's the same thing. That's my point. It's like you're just,
Well, I'm
you're
not-
putting this on me.
We're also not gonna tell you exactly what, whether or not.
Yeah, we're not
This
gonna give
is-
you a guarantee right now
Right.
when we haven't seen what we wanna see. I mean, that's just the way it is. I'm not saying that that's right, I'm not saying that that's wrong, but I do know that there's not enough information for me to determine that what I'm seeing on those drawings is correct.
Okay.
Because I do this for a living, so I'm telling you, there's not enough information for me to determine whether or not it's correct. I believe you did what you thought was right, and it may,
I did what I was asked.
and it may turn out to be.
And I've done that,
100%.
and I've constantly done that, and that's probably what I have to keep doing, but it's becoming crazy.
Well, That's
Well, you're gonna have a vote on it,
Okay,
or?
so,
I don't think we have anything to vote on for the sightlines.
so how do we wanna put together a list of, we should draft something up specifically stating what we want?
Yeah, because here's my problem. You guys asked for something,
Yep.
and I gave it to you,
Agreed.
which I thought we had, somewhat of a determination.
So we had preliminary, but you
Right.
now have.
Now you're asking for something else.
So we had enough information to have a discussion, and now we have a lot of additional information, including concerns expressed by your adjacent neighbors that we didn't have before. And so we have to continue to work through the process of due diligence.
Sure.
So that's,
So what are you requesting then?
so is it,
Boundary survey, topographical survey, the proposed house plotted on there with proposed grades around the house, however you're proposing to grade this entire lot, so that we can see how everything lays out together.
and you said including the adjacents?
Yeah. Front and rear of the adjacent houses, so that we can see how those things are. It's the only way we're gonna be able to determine it.
Okay, is there anything else anybody else would like to see?
I think it would be worth noting on when he gets that survey that Dave mentioned, that the plan for moving materials and stuff around, since it's a tight area around their current house to the boundary lines. I don't know if it comes into play here, if that will come into play at the
Yeah,
next.
so
meeting.
let's,
Later, because
yeah,
that's
so
not
let's,
like-
Might be
yeah,
later,
let's
Commission.
keep issues separate like
Yeah.
that, because the reality is, sightline determination is that coming up with an approved Livingston County building plan and permits
That's
and
separate.
movements is really logistics and all that. Okay, so I think what we ought to do is, so we have an,
One other statement, if I can.
always,
And if I'm wrong, please correct me. You asked the question whether or not you had to provide 360-degree views. And you people have made the comment, or some variation thereof, so correct me if I get it wrong, that, you have a existing view that's, the best view on the lake, et cetera. Now, no, you don't have to protect 360 degrees of view. And unfortunately, we respect the sight lines and we're gonna do the best to make everybody happy, but you're not necessarily, unless I'm missing something along the line, entitled to the exact view you have now.
Why?
Because you would be blocking off potential people from building next door.
so,
How?
Not-
He could build
Well,
back.
that sight line, right?
He could build that same
No, no,
home
no,
back.
yeah, right, and he could build that same home back, but that's still gonna impede the sight line that you have now, to some degree, it potentially could.
No.
Yeah, it would.
Well,
If he
it,
goes back, he's gonna go up.
so
we're
here's,
just saying
yeah,
that,
here's.
if you're the first house on the lot, on the lake, and you've got, 270-degree view of the lake, you're not guaranteed to have that forever, because other people are gonna come in there and build. It's our job to try to make sure that it is equally for everybody, the best possible. We can't stop him from building.
And we don't want that to happen.
Okay, I'm just trying to say that, we're not saying we're gonna come in there and take away your sight lines entirely. We're just, what I'm trying to say is, it's gonna be a give and take. He doesn't have to protect all 360 degrees, and you may end up, losing a little corner or something like that.
A little corner would be better than what's proposed right
Okay,
now.
I just wanna make sure that everybody's on the same page here.
So if I understand that correctly, we could build in front of him.
So here's, yeah, so here's, as best as I can try to add on to what Dave said, here's the reality. So whether it's our municipality or other municipalities and we'll just stay focused on the state of Michigan, okay, and inclusive of, let's just say it's the southern portion of the state. Awful lot of lakes around here are in communities that have sightline preservation clauses or aspects to their zoning ordinance. And they use varying methods depending upon the topography of the lakes, the shapes of the lakes, and they have different standards. And every one of them is different, and every one of them, somebody could argue, is good, bad, or indifferent, depending on whether you are the new builder or the existing resident. What Tyrone Township currently has is a simplistic assessment and then an obligation to attempt to minimize adjacent neighbor conflicts, right, which means compromise, right? So that's what we're trying to do here, and as Dave said, if you have, and just to use the example up here, so currently, and we'll unfortunately pick on somebody here, so this house currently has a view like this, right? So you basically can see, because of the elevation, as was said, you almost have a 180-degree view of the lake. The reality is that in most communities, you get something you're entitled to that is somewhere between your lot lines and maybe about those dimensions right there. Not that that's just what happened on this drawing, I'm just giving you a close approximation. And they're calculated in different ways. What Tyrone Township does right now is uses an averaging that suggests that the way to mitigate, and again, you'll notice in those regulations, for those of you who look, there's nothing there with topography. So what it literally says is house A, house B, draw a line, and the next house should be behind that line or not go before that line.
Right.
That is not hard, set, and fast. That is the starting point, and that is the initial assessment, because again, topography, single story versus two story versus three story versus lower level walkout versus a number of other factors come into play. So as Dave said, our objective here is to understand as much as we can about what the potential impacts are and try to figure out how to work with people, even when they don't necessarily get along, to minimize that impact and share the pain amongst everybody, because everybody is going to encounter this for the most part at some point in their or the future owner's life. So, the lakes around the township, Runyon Lake is a great example. It's an old cottage community that's continued to grow since the 1930s, and there are homes that are being built now that are replacing cottages, and they're simply larger than the cottages, right? And therefore they take up more space. Some of the lots are large, some are not, some are high, some are not. And so Tyrone Township has tried to figure out how to mitigate the conflicts as best it can. We didn't say we could prevent them. We also know we won't satisfy everyone. But again, we're going to get some additional information, try to make a better assessment here, since there are concerns being raised about more conflict here maybe than is initially thought. And we'll see if we can't work with everybody to come up with something that's mutually agreeable. So that's our plan right now. Someone did mention that we are in the process of considering revising or adding to our regulations for sightlines. Actually, what we're trying to do is formalize the process a little more, so that there's some hard calculations and methods, so that the discussions about, well, how much does it disenfranchise one versus the other, that's a little more concrete and not as subjective as some people make it. That still will not solve all the situations and conditions. So hopefully what we can do is gather enough information, share that with everybody, whether we do that individually or together, and see if we can get everybody on the same page relative to what everybody thinks the impact is, and come up with a compromise, if that makes sense to everybody.
Yes.
Okay. We will draft a letter to you, okay, that very specifically asks you what we're asking
Right.
for, so that you know what it is, and nobody comes back later and says,
That's what I want to get away from, because
Yep.
I'll do something, and then all of a sudden it's not enough, and then they want something else.
Yep.
So,
Yep, so at this point, we've gone from preliminary to now we're informal, and so we'll get a list, and that should be it.
Okay, then, once I submit the new thing,
Mhm.
then what?
Well, so we're back to, as I just said, what we're gonna end up having to do, the planning commission is gonna have to look at this. We're gonna consult with your neighbors as well, try to get everybody on the same page. Again, whether we have to do it separately or we can do it together, together would be best.
So are we doing a meeting, or are we doing another?
We will offer that up Once we have the information, we will absolutely offer that up. And again, if people wanna do it individually, we'll do that as well. But we will, with you in particular, we will definitely have you at a meeting. The other folks can attend if they want to. But again, our expectation would be we get enough information to share with everybody, get at least a common understanding of what we think the conflicts are, if there are any, and then see what everybody might be agreeable to as far as ways to mitigate those conflicts. Again, realizing that we probably aren't gonna get rid of all of them. All right, but minimize the impact. Okay,
All right.
sound fair? Or at least reasonable?
Can I ask a
Yes, ma'am.
question? We weren't notified by the township about this meeting, and if it hadn't been that he approached my brother about signing off and allowing him to do what he wanted, we would have never known about this. Should you have notified us? What would have happened if we didn't know about this?
I'm not sure I can answer that specifically because I don't know what the conversation would have been amongst all the planning commissioners with the information we had. What I will simply offer up is that the new process that we are considering, if that is adopted, would require adjacent neighbor notification. Right now, this is a planning commission assessment, that's what's in the ordinance, so it actually doesn't require neighbor involvement. We encourage neighbor involvement, so we did actually encourage that you be contacted by the applicant and notified of this. So that's the process we have right now. We recognize that that arguably could be improved so that neighbors at least know what's going on.
Thank you.
Appreciate it.
Okay?
Thank you.
Okay, so that'll close that subject, and then we've got one more topic here with Mr. Bentley, which is regarding the use of the existing structure.
And I already know what I'd like to say about that subject.
Okay. Well, that's this document right here. Let me get rid of some stuff. I'll leave that up just in case. Okay, so we've got, a intro here. So again, Mark, just to clarify here, what I think I heard you say a few minutes ago is that your current plan is that you would live in the existing home up to the point where at some point it's deemed that you're unable to complete the remainder of the construction because
Right.
that's gonna have some sort of.
Well, I don't think I'll be, I mean, obviously I can't do final grade until I get the structure out of there.
Okay,
So, I think most of it I can do without, but
so
until it doesn't make sense anymore, it's just gonna have to go.
Yeah, so from your thought process at the moment, would you think that you would be living there for the first 3 months of construction? Do you have a rough idea, time period wise? Let's say, and I know you don't know, have a start of construction date necessarily right now, but when you said if we said start of construction is tomorrow, and I realize it's a swag, would you think 2 months, 3 months, 4 months? Do you have a rough idea of how long you might occupy?
I have no idea, like I said, till it makes sense where I can't do it anymore.
Do you have
Which
a,
is basically gonna be trying to get the driveway cut out and.
has anybody given you a rough estimate of total construction time?
No, because I don't know how long this is gonna take, I don't know how long going through the county's gonna take,
Okay,
you know, I mean.
but you don't have contractors or anything that have said if, when I get the go-ahead,
Oh,
it'll
yeah, I
take
have,
this long?
yeah, I have contractors lined up, but I
Okay.
can't.
But, so what have they told you as far as if you started tomorrow, how long are they projecting it would take?
What do you mean, like my foundation kind
No,
of?
No.
how long is their construction? 9 months?
I'm building the house, so it's kind of,
Your general?
yes.
Okay,
Yeah.
Okay.
all right, didn't understand that. All right, then we got a note from Greg that we had him do. Do you wanna look at that, or do you wanna make, your comments, or
I
what?
guess my comments would be, this is directly affected by whatever we find out with the sight line, so is it imperative that we deal with this tonight, or do we wanna put this on hold until we're dealing with sight lines?
Well, I
So-
understand what you're saying, Dave, but, I think they're also, I mean, he's asking for a temporary dwelling. Well, if he can't, because he has to move the house back, then he can't.
Right, so it'd be basically, the application would be no. I mean,
Right.
you can refund my money on that.
See, not that one, not that one, not that one.
It's crazy
I
tough.
think the one way the two things are related is, how is he going to access the construction site across?
Right.
The topographical survey and the grading plan.
I think it bears on whether or not the temporary dwelling, application is reasonable, right?
How much space is on either side of the house between the existing house and the property lines? Yes, I think that, some of those questions are probably the reason that we need a scale drawing.
I mean, there's plenty of property around the corner, which I plan on prepping that. I mean, I'm not doing the shared road thing anymore, that's gone. I mean, that side, basically, I have a hill, and I've already removed all the timbers from the hill. It was like an old, retaining wall that they had over
So
there.
you're talking about this area here? I'm
Yeah,
assuming?
along that one side,
Okay,
where that road that we were talking about.
okay.
So I've already removed all the timbers. They had like an old retaining wall, and there was some trees along that edge.
So
Like
do
I've
you-
already removed those.
So do you have a rough idea of what the distance is between the side of the house
From
and
the
the
property line to the corner of the house, probably roughly 20 feet.
But yeah, like Dave said, that map would answer all these
Right.
definitively.
Can I address the board?
Yeah, sure, go ahead.
It looks like, according to, plan sheet P1, that the setback is only 10 feet to the house, from the property line,
You talking about the new house or the old house?
the new house.
Well, yeah, we're talking about the
Yeah,
old
yeah,
house.
yeah, so,
I
yeah, so,
apologize.
yeah, so at this point, the question was just trying to begin to get an idea of whether or not you could actually get equipment between the adjacent property, between the two houses, and stay on his property.
I mean, I've already had the discussion. Basically, if there's a garage on that one side, like, my thought was if at the bare, if I had to, I could demolish the garage.
So you're saying,
Access.
so this right here is section
Right,
is what
that's
you're
all the
saying?
garage right there.
Gotcha.
Right. So, I mean, it would make the construction a lot easier if I tore down that garage. I just have to find a place to put all my stuff.
Gotcha.
But it would make it a lot easier.
All right.
But it's not impossible. I've already had contractors look at it, and they basically have no issue with it.
Why does that thing keep blacking out? Greg, we got your letter here that you prepared. Did you want to summarize your findings and?
Well, I think, besides the plan requirements, I think the main question is why are opposed? So, obviously, the plan does not meet the information requirements that are set forth in the standards there, in the temporary housing
Okay, so we're,
section, which,
yeah, so we're back
which
to.
you're showing, and so, his new plan undoubtedly will meet those requirements, so that, that'll be resolved. There is a question of timing, which you were trying to get to. The ordinance allows, for this, for a maximum of 10 months. I don't know how that jives with your.
I don't see it being 10 months.
Well, and even if it was for whatever reason, I mean, the township has a pretty strong history of working with folks as long as they're making progress on the home that they've extended.
Right, I mean, they're obviously not gonna give me a final bill or C of O until that house is gone, so.
The written agreement is of course critical. I don't know if you want a form of one to consider when you're considering the request, but, that it needs, at the end of the day, as it relates to the, temporary housing, request, you're making a recommendation to the township board.
Correct. Yep, and typically what we've, go ahead, I'm sorry.
Ultimately has the authority to approve it, you make a recommendation, Ross does as well. At the time that it goes to them, there needs to be a written agreement that they're comfortable with, that assures them that the temporary home will be removed in a timely fashion, and they have the ability to require security for that as well if they choose.
Right.
It's not mandatory. They can
Yeah,
choose to.
usually what we've done historically is, you know, we provide our findings relative to risk compatibility, things like that. And then what we do is we just, you know, suggest to the township board that they, you know, consider a, you know, some sort of, whether it's escrow or guarantee, whatever the case may be, that meets, you know, their level of satisfaction, and we just let them deal with that.
But other than that, other than the process comments that I went through there, our observation was simply that, you know, it's reasonable in concept, but whether it's practical turns on whether or not you can get around the existing structure to do the construction that's proposed.
All right, so everybody's kind of on the same page with respect to that. Did that cover everything that you were thinking of or wanting to say?
It covers it.
Yeah, okay. All right, so bottom line is, I guess, in summary, the plan that we're looking for that will help us better understand the elevation and sightline issues should be sufficient to satisfy the requirements for the documentation we need for the temporary structure. And then collectively, we can make an assessment, and then if we think that the temporary structure option looks feasible, then we can make a recommendation to the township board, and they can make a decision as to what sort of financial guarantee or other instrument they would like to pursue, if any. That makes sense, Kurt? Okay. All right, other questions or comments from the planning commission? So it sounds like the best thing to do for us is gonna be to table this pending receipt of the,
Make a motion that we table the Bentley temporary structure, Eastern Construction.
Support?
Subject to receiving updated drawings and a written statement.
For a form of written agreement.
Yeah.
For removal.
let's see, so, talks and form. Okay, so motion and a second to table the Bentley temporary structured use during construction application, pending receipt of additional documentation, which provides us with some dimensional information, and then an agreement of sorts, a proposed agreement of sorts that would.
All of the requirements stated in the McKenna letter.
Yeah. Yeah,
Dated February 11th.
yeah, that's the best way to do it, that's set forth in the McKenna letter dated February 11th, 2020. Yeah. Oh, good, excellent, thank you for that. Any further discussion? All in favor, please say aye.
Aye.
Anybody opposed? Motion carries. All right. So again, we'll write a quick summary up and clarify that for you as well.
Yeah.
Bottom line is everything else that is on that other list, we'll take care of all this, and the only thing that we'll end up doing is providing you with some sort of preliminary draft that would propose, and Ross and I were talking to a couple of the township board members about this, but just to see what their thoughts are on what, if any, financial guarantee or something they want.
Right, well, that's kind of a
whatever
foregone
the issue is.
conclusion until we get past
Yeah,
the other issue.
yeah.
So, I guess just, Ross can email me
Yep.
exactly what you guys want, so,
Yeah.
there's no,
Yeah, absolutely. No, we'll make it, I use the term formal, but I mean, it's typical what we do in this process, because as you're suggesting, we don't want any misunderstanding, we want it to be clear what the requirements are, everybody's on the same page, and then we'll just go from there.
Yep.
Okay. Excellent, thank you, sir.
Yep.
Okay, so that takes care of those couple of topics. So those of you that were interested only in those two topics, you're obviously free to leave. If you want to stick around and continue the planning commission party with the rest of us, you're more than welcome.
Please.
Can I just say something
Yeah, you may, go ahead.
off the record?
Yeah, yeah,
My name is Bonnie Wentz. I'm another Landers.
okay.
Thank you for your time. I know you don't have an easy job, and the best, whatever it may be.
Thank you.
Thank you.
Appreciate it. And again, seriously, thanks everybody for being here. Actually, we're all very glad you were able to show up and participate in the process, so just thank you for that.
We were sort of blindsided a little bit. So
Yeah, and
that's-
you know, again, that's one of the weaknesses that we've arguably identified in the current process, so this is probably a reinforcement of that and, you know, a good lesson learned to, you know, proactively seek out the participation, even if we think we've gotten it in our current process, which we obviously didn't.
Well, we appreciate you
Our
taking.
father's legacy that's leaving, that they're trying to protect.
Yep, understand.
And
Thank you so much.
No, thank you.
We invite you to come out to the house and actually look at the grades and the current.
And some of us have actually been by there already,
Okay.
so
Okay. Yeah.
we're trying to do that, which is why we've been working through the process, is trying to get some initial renderings and try to get more convinced that there is or is not something there, and then what additional information might be required that's more scientific, to use our engineering terms.
Sure. That's fair. That's fair. We appreciate it. Thank you
Yep,
very much.
thank you. Yep, have a good
Have a
evening.
good night.
Thank you.
Can I approach?
Yeah.
Being a little
You want
naive
the
about how.
pictures back?
No, oh, that one, yeah, thank
You
you.
might want.
When you said that, statement that I didn't that I never knew, that we don't get to keep the site we bought, is that like every township, every city in America, or?
Virtually everyone in Minneapolis.
So,
Pretty much.
Is
If
it?
you own
Okay.
the land,
There's just a different, everybody calculates that
differently.
view differently, but they all come back to about the same argument.
So, I just happened to have the, opportunity to meet with the lawyer, with the other two neighbors. So, taking this to a legal, question
Well,
You wouldn't have to do that until we make our decision.
Right.
Yeah, I mean, here's the thing, I guess, our point of view would be, you always have that option, right? But your argument, for the most part, as far as property rights, is either gonna be to find a defect in our ordinance, right? Or find something in our ordinance that doesn't comply with either a statutory or some other regulation law, that has some provision that we don't have incorporated in our ordinance, which would get back to, it's arguably a defect, right? So.
I mean, I'm not
Yeah, no,
saying
no.
I'm prepared to do
Yes.
anything like that. I never even thought
No,
I would need a lawyer
Right.
to understand it, but obviously I did. She gave me a lot of information I didn't know.
And in fact,
So-
with the concerns that you folks have, I think we would all here recommend that you do talk to a lawyer, you know, that has some knowledge of either riparian law or property rights or municipal law. And try to,
Regarding an easement.
yeah, and try to get some
And she
perspective.
spoke to the easement because they did talk, and that does go
How about
with the
that?
purchase of his property. She said it's grandfathered in, so he's got it whether he likes it or not.
After 15
Oh, the
years
shared
of usage that
Yeah.
both use,
Mhm.
it becomes law that they both have access, and neither one.
I mean,
I would
she
get
heard
that.
shot
that.
the other
It
one
wasn't
off.
my
I'll
place to
verify that
speak
one
for
more
her
time.
because she
Right.
heard
I'll
it. She
get
was
that
on a phone
lawyer
conversation.
Yeah. But so our challenge again is, in these cases, is
big difference.
we try to draw
if it's
lines like
access
this,
versus
and we
not
try to sit
access.
there and say, okay,
Right.
what is a
The
reasonable view?
The property
Yeah.
doesn't rely on.
And
that
I
for
understand
that.
that.
Yeah, and there's
I
no-
mean,
Well,
it
right
doesn't-
now, because they
I
did
just thought
change,
he bought it, it's his.
the other one
nobody can
did
take
build
it
up
away from
above
him.
Yeah.
the.
And so what we were kind of hoping
For access
is, you know,
to
from a
public
perspective
way,
point of
right?
view,
Your property,
if
their property.
this is
the other
real,
property,
and
they
that
all
was
have
really
that
at ground
access
level in
on
which
a
you could
public
see,
street.
That's actually a
driveway
better view than most of the
is
people on the lake
a
have.
convenience.
Right,
In
and see,
most locations.
That's right.
this is what you
Yeah.
have.
Well, they moved the cottage back up.
It's
That's
other
where,
people's property.
so that
you're
access
viewing
really
over.
doesn't
I
need.
That's
understand, I understand,
As much
it's
now.
not historically, and as I said, it doesn't mean much now.
Right.
And
Right.
for that
But
reason,
see, this is other people's property.
the
over here.
ability
I
to
see.
have.
So you have to
That's where we
recognize
have
that.
to try to
May
Yeah,
not be
because,
everybody has to.
because everybody has to.
Yeah,
They
it
have
loses
to-
a little bit of the
Sure,
site.
and that's a good thing.
Yeah, this whole thing called air
But I mean,
rates
the-
or sightline
the
views
lawyer
and all
did
that.
Make us
I mean,
realize about
there's
the
a bit of
code
I guess we've been
36.
spoiled.
Yeah,
that-
yeah, a lot of us
that
have.
you
Because it's been
have
nice,
the
you can see
adjacent
the ski
properties
coming in and,
Right.
you know.
of your
and-
line of sight,
And all
that
of the
you
wonderful
go
things
to
that go on that.
the
Yeah.
adjacent
Anyway, thank you.
property.
Yep,
I
no,
know.
thank
Sorry to
you,
take-
appreciate it.
It isn't that you go across the
Sure.
the lake
Okay.
and have to
This
establish.
picture to go from that.
Thank you, gentlemen.
This is what you have, that's what you're gonna end up with.
Right,
Yeah.
These two.
yeah.
Hey Greg, side note, or side question. Okay, if he provides us with a topographical survey and architectural plans, if I got a quote from somebody to do our own 3D rendering, do we have the right to ask for more in escrow from him?
For the sightline determination,
Yeah,
based on what we have in our ordinance,
yeah.
that's a question for him.
Oh, that's why I just started
I
asking.
like how you ask it. I don't know what you have in your ordinance, so.
Because that's something that I think would go a long way. If-
Or we need to use our board liaison here and, or you and I, the three of us or whatever, or Ross or all of us, we go talk to a couple of the township board officials and say, hey, in this case, it would be in our collective best interest to spend a couple $100.
I think it'd be
And-
more than.
Yeah, it's
Yeah.
more like a couple
Yeah.
$100.
I'm just saying, you know,
Was
some
it,
of these,
Was
it's,
it BOARD or BORED?
So,
Yes.
Dave, we don't have a fee established for this, we don't even have an application process defined in the ordinance for this, it's just.
For sightlines?
right, it's just, yeah, it's
I-
just
I
a,
had-
it's a
I
planning
know a
commission
firm that could do it.
interpretation and determination,
Yeah.
which is highly informal, which is why I really wanna
At
amend.
least we have, I don't think we even have.
Yeah, cause it says the planning commission will
Yeah,
determine
and-
the appropriate setback.
And again,
Well, that's a catch-all, and
Yeah.
it's good.
it is, but I mean, the lessons learned the last couple of years, when we ended up going through documents in Peabody, was
even a fair
things that
No, cause it was,
previously
you know,
hadn't been
kinda like
huge
the one that was
players
at
in
Morrow
this.
Lake.
Elevation,
there was
significant
woods, people
hill,
couldn't
like
see
we're
anything,
talking
and
about
then they
here.
opened it up. and-
Also,
want a house there.
Yeah, yeah.
existing adjacent development
can't live
that
like
is
that.
And
surrounded
that,
by,
the reason that that is so
I should say,
misleading,
existing,
looking at it the way it is,
pre-existing
is because his
cottages
proposed house,
from the
that end that's facing us,
1940s or
is so much
50s
farther
that
this
are now
way
surrounded
than
by
everything
various
else.
stages of
And that's
development
why
from the
they're having a
60s
hard
and
time
later,
seeing
right?
what
And people
seeing
wanting
what-
to improve that
I
property
think they're seeing
from
what they're seeing,
cottage
I
to
think they're
full-time
right.
residence.
But he's able
And
to
again,
convince
in
them
this
that they're
particular
not by
case with
saying,
Peabody documents,
"Well, the
conflicting
ceiling of
topography,
this
where
is
some were
at
located
that
low,
elevation,
some were
well,
high.
yeah, it might be,
And then
but
people
you're
also
also
put
60
monster
feet
houses
farther
in
this
and
way.
all this. And
Yeah, I
then
mean, your picture
the real
here,
lesson learned with,
this is the same picture
Peabody
with that.
was that if you have a
superimposed
contractor
in there.
that on the applicant's
And,
behalf
you know,
provides information that
It's
turns
gonna
out
block
to
some
be
of their view.
inaccurate,
It's just,
and something
it's
is
just,
built
what's the
that is
question?
not
It isn't
representative of what it's
75%,
supposed to be,
because
like
you
it's
don't-
8 feet
we
higher than
don't
it's
own
supposed to
this
be.
over here, this whole
And
view
they
isn't.
forget to include
I own
amenities
the
on the
whole
side,
view,
like how to
no.
get in the house, because they wanna
Because
get in the
you're-
side instead of
you're
through the garage,
looking
like
at
everybody
lots,
thought. And now they
15
need a
lots now.
walkway that encroaches,
And
and
this,
all this other
to
stuff.
me, this is
They're like,
not.
this is now enough instances
Because if
where
you
we need
look at it
something a
from
little
here,
more formal. Check the boxes off, go through a process, have something that is
the same
as
tree.
repeatable as
Something is
possible,
just
that
off.
incorporates
It's
all
off
the
perspective,
various
I'll tell you that.
issues that crop
And
up,
that's what
right?
I'm saying, if
So you
we
can kind of
had,
just work through these things more
we have that
formally
information,
instead of,
yeah.
well, you're just making a determination and you
there
don't
is
really
a
have any
firm that I could
standards. Well,
contact that could
we do
take
have standards, right?
and
It
make
says
that
take the average
round,
setback
three-dimensional.
of the
Yeah,
adjacent
that-
homes and put
that
there.
three-dimensional
But
house
to be
on
fair, that doesn't
We can
include
bring it in here
topography
and put it
or
on the
the
big
height
screen
of the
and spin it
houses.
360
I have
degrees
a
and look
feeling
at it
though,
from
he's
straight
gonna
up
come
in the
back and
ground
say,
or
he's
standing
in
down
line
the
with that
ground.
You know,
garage.
and if you come in here
So
and
we
be,
have to
I'm
be
the new
prepared to
owner
say,
in
well,
town, and I'm
yeah,
gonna
he
tell you
doesn't
what
do
we're
himself
doing.
any
It doesn't say that in
So,
footnote
no,
X,
he's not.
but it does in that diagram, so it's,
So,
And in the
So-
And
definition.
it's
because
not everyone, I would agree with you
That's
completely
great.
that that's
Yeah,
irrelevant
you're
because
gonna-
it's
you're
the
gonna
principal
lose it.
structure.
It is,
right?
but
But-
based on his drawing
Right,
he
some
submitted.
additional
and-
clarification. I'm just
Yeah.
hoping what happens is that he comes back with a little more formal documentation, and we find out that the roof line is 6 feet shorter than people
Yeah.
think it is.
Well, I'm sure that's
And
probably.
so
Yeah,
most or
you
all
use
this
that's
goes
always
away.
makes money.
I don't know, I don't think they're gonna want it down at that, in that site, in that spot on the
I
site.
have no disagreement that the adjacent neighbors
deal
prefer
with
that
the
that
guy
can be
next to
set back
him,
closer to the
in
road,
big
which is
house,
arguably
who
the
has a little
development pattern
place
and
down
intent
there
of
that
that
you
area.
can drive
Yeah.
to.
But the question is what right, if any, do we have
They're
to
not gonna be able to
require
get
it
down
be moved back,
Right.
absent the
Basically
sightline
put
conflict?
a 8-foot
That's the
fence
only
up
thing we
there or
have.
something
Exactly.
such.
We do have that.
He'll make your
But
life
we may,
easier.
right, which is why
If
we're
it's
trying to get some additional
reasonable.
He's
information.
already done that to everybody here, so.
Question. In our, temporary
Yeah,
dwelling units,
Their biggest concern
first
really is the access.
1 and
drive.
2,
That's
one of them
all
describes
she was saying. I
a,
explained to her, this is
house
not
destroyed
public
by
area,
fire or
it's
something
on
like that.
site
The other one
lots.
says a mobile home thing.
No one be-
Right.
There's no discussion about utilizing a fully existing house.
Right, no.
And I
But,
just-
and yet those two, sections are arguably distinct from the one that I went through, which is, you know, section 3,
Mhm.
right?
And he's gonna have to demolish that place before he's ready to move into the new home.
Well, he doesn't have to, but that's back to what are the terms and conditions.
Because he can't get the final grade and
I
stuff, so how's
I
he?
still say
I-
there's a reason for this, and
I
it's
would-
not because he wants to
I
live
would
in the
agree
house.
that that's the
Yeah.
practical difficulty, but that's,
Well, no, he wants
other
to
than that, he
put
doesn't
it,
have to do
he
it.
wants to be able to stay in his house before so he doesn't have to rent a hotel or stay at a friend's house.
Right, but he's gonna have to put a tent up.
Not buying it.
You don't think so?
Nope.
Well,
Well, he's
would be a
building
condition
the
of
house,
the
though, too,
permit.
I think,
so-
I think that's, I don't think
That'd
we
be a
can keep
condition,
that
a
up.
stipulation.
Yeah, I don't
of the
think-
permit here.
Right, but what I'm saying is
hang on,
he's
hang on,
doing this for.
hang on, just a second. Did you verify everybody kind of walked out?
Yes.
Okay.
Yep.
All right.
Particularly if he
Lock
drops
the
the
door.
garage, you know, he's.
That's what I think the entire issue is. It's not that he wants to get closer to the lake or anything else. If he built that house, the front of that house, up where everybody else's front is, these people would all be happy. But he'd be one entire garage short. Because that garage that is all of a sudden on top, going straight out into the road, won't exist anymore. Because that would be a second-story garage with nothing.
But he sort of volunteered to
Tear it down.
tear down the garage and still live in the
No,
house.
Yeah, tear down the house, the garage on the existing house. What I'm saying is that if that existing house, if he was not trying to live in it, and you took that proposed house that he has right now, and you slid it up 40 feet, so it was in line with everybody else's, he would lose the top garage on that house, because it would be sitting 10 feet out of the air. There would be no ability to have two garages. That's his whole reason for doing this.
Oh, yeah.
Look at the
Yeah,
Let's go
side
back to
view.
that other
Yeah,
picture.
that's true.
Yeah, which makes sense.
Is, this one, I think. Yeah.
Yeah, now look at the profile one. Okay,
Oh,
now,
the
if
bonus
we
room?
take this thing right here and shove this 40 feet up, so it's up here.
You can't,
This is a garage,
yeah,
on top of a garage.
yep,
How's he getting in? No, that's a bonus room.
No,
obviously.
that is a garage.
yeah, that's the way it's
Look
set
at the
up.
front
Yeah,
view.
this right here is a driveway. Whoops, I'm
Look
doing
at-
the pin
look
in
at
it.
the
This right
profile.
here.
Oh, so you mean the retaining
Yeah, this
wall
is a
lines
garage,
up?
and this is a
This
garage.
retaining wall is,
Is right
so he can
here.
get down to
Oh.
here. There's a driveway on top of this going
Yeah.
into this top garage.
Yeah, so there's really a two-story garage.
Oh, into
there.
his current one, but would go into that top one. I see what you're saying.
Yeah,
Yeah.
so he's got a garage on top of a garage.
Interesting.
So if you move this thing up, he loses one. And being a contractor with all this storage stuff, I
Yeah,
think
you
that-
need it, yeah, yeah.
Well,
But, you know, for real estate, it makes sense why he's putting it there.
Oh, he
yeah,
wants
like
he
you were
wants
saying,
an
yeah.
excuse to put it down in the location that he is. And the excuse is, I wanna live in my existing house. I'll put money on it right now, he gets a permit, and it's less than a month after he starts construction, and he tears down that house with the excuse, well, I just can't do it because of access and everything else. When the whole reason was for that existing, that second story garage.
I'm actually really concerned about the grading he's talking about doing.
Oh,
for
I am
their
too.
Stability or
If
lack thereof.
If I was next door to him, you know, one of his neighbors there, that's,
Well, that was Anderson.
yeah.
I mean, I told you guys, they about lost the backside of their house. That almost went down the hill because that was so unstable back there. And they had those multi-ton rocks in there and they let loose and just about went down the hill. So, I mean, that area over there is not stable. Anyway, and it's Runyon Lake, it's all freaking marl,
Yeah.
right? So all the ground does is get wet and it turns basically into wet concrete, for lack of a better way to describe the texture. And then when it dries out, it's literally concrete. It's harder than a rock. I got an area by my accessory building where I drive through right now in this kind of weather, and I literally sink about an inch and a half. It's sponge. You sink when you go over it. And then in the summer, when it's dry, I mean, I can go out there with a hammer
Oh, yeah.
and spike, and I can't, you can't get,
Back on that
No,
side.
retaining walls
you
right
can't
here
get an
hold
inch
this
into
up,
that
so the
stuff.
driveway
Yeah.
comes into this.
It's just
And then the
unbelievable
garage
how
doors
hard
that
it
you're
is and
seeing
how
here
soft it is.
are right here.
And you walk out there and
Yeah, no, I
right
get
now,
it
if I
now.
get out,
That
my
makes
feet
sense.
just,
That's what,
he
in my
must-
opinion,
yeah.
that's why he's got
it's
that
just,
down there.
it's like a sponge.
Two
It's
garages.
unbelievable.
It's got suction too.
Mm.
Yeah, yeah, yeah.
Oh, yeah, you
Yeah.
can put in that stuff,
Yes.
Yep.
I live
Yeah, he
on
said he
Lake
was.
there, I know exactly.
Like I said, he
where
was
that is.
general.
He's
It's
gonna
not-
be all
It's
Oh,
not, it's not the same.
Oh, yeah, true, yeah, he didn't, yeah, I told him I could get
If you
one
moved that
done.
thing all the way up with everybody else's, we wouldn't even be having this argument.
Well, when Ross and I put this
Yes,
agenda
well,
together,
yeah,
I
I
had to
got
think of
40
this
feet
initial
and everything.
topic at the time was gonna
Yeah,
be
why couldn't he,
15
why couldn't he
minutes.
still have his
And the
house
second one
built?
might be another 15.
He
We're
could,
like,
yeah.
yeah, we could get to this, we might wanna add
He
that.
could,
let's
he'd
not
have
add
to
something
build
else,
his
'cause he
garage
might
and
be-
He moves that up.
Yeah, you're
when he
right.
moves
Yeah, as
that
soon as we
up.
do that, we know it's going downhill.
This thing has to be up at the top elevation, so now this thing's sitting out of the ground by 10 feet.
Yeah, cause if he moves it back this way, the house moves up.
Yeah.
Well, I understand.
But, and so,
It moves up unless
And
you
this- and
move
this-
the earth that's in the way.
Well, yeah, the only way he could
but
do
he
it like
couldn't, he
this,
couldn't get down to
I mean,
there.
another way that he
He
could
could.
From the
arguably
road,
mitigate some of
down,
that would
down
be
at
to
this
knock that.
elevation.
he could if he took this
612 down to a
wall and
412.
put it along
Yeah.
that property line.
Yeah.
Right,
No,
that-
but I
that's
think,
not gonna be
I don't know,
2
I mean,
feet or
without
something
going out
off
there
the-
though, I would assume that
That's-
this
Is
slope
he
to
having
the
a
road.
Yeah,
feet?
If he moved it back, it would be too much of
Well,
a
it looks
slope
like that
down.
top,
yeah,
part,
you
that's a
can
good
drop it
question.
8
It
feet,
looked like
40
that
feet.
top
He
part
wouldn't
was
be
almost
able
just
to-
roof, but I guess I don't
Yeah.
know that.
Yeah, it
That's a
would
good
be
point. I mean, the way the drawing is laid out almost implies that that's not the
convinced that's
case,
what
but
he's
he's a
But even if-
contractor,
even
why
how
wouldn't
it's
it be? Why
proposed,
wouldn't that be cathedral?
Their sightline is still
It's
pretty
like
awesome
beams kinda.
compared to a lot
Well,
of people
that's the
out there.
decorative out on the so-called porch, yeah.
Oh,
But you know,
yeah.
it's a fair question though, you know, what is this in here? Is it really cathedral or is it just 612 because
Their sightline's still
architecturally
great
people like the
compared
6
to-
and 812 roofs?
It is, I'm of the mind.
Even though
that-
to me,
yeah.
once you go above 612, you're just asking for a
I
nightmare
think it
for
would be a
anybody to
solution
roof.
for it, like,
In line
to live
with,
there.
the- yeah,
It-
well,
it is
not
gonna
only
be
that,
one of
I
but
was, I would.
How is this thing?
I'd say just move it back.
I don't know, I mean, I'm personally, just from what I see, it's not,
But
maybe it's not my first choice, but I don't know that that it'll look bad.
I would hate to be the people to
Because you're,
Yeah, this
because
is
you're
okay.
sloping the south back.
that's
They're
the
not
Anderson.
entitled to the
Yeah,
whole-
'cause you're gonna,
Yeah.
with this garage,
Mhm.
double stacked, you're gonna see nothing but a giant wall right
Well,
next to it.
I mean, to be fair, I mean, is this, let me see, is this, oh, no, this isn't it. That other drawing that I have, but, I mean, the reality is that's what happened when Anderson built is with these lots, the way they are, is, you know, Pereira basically can barely get in his driveway to turn into his garage.
Yeah.
So all that stuff just ends up being tight, but I mean, that's what happens when you
Lake living.
take these, you know, big, wide, huge houses and you plop them up there, and in some cases like this, it's like, well, we can't make it long because there's topography, so we gotta make it wide, so now, I mean, it's
To our
just,
max.
yeah,
Max out the property line, it's Lake living, you know,
Yep.
that's what happens.
yeah.
That's
I worked in Waterford for a number of years, we had 34 lakes and people would.
That purple, that house to the south?
To this one right here,
Brand new, like, only like 5 years old or something.
yeah, so this one in Anderson, I wouldn't say it's purple, it's stone. I would call it more like a taupe, you know, kind of a
Well,
neutral.
Waterford is the way it is, though.
I wanna say they lost their son.
Being down there that far.
I mean, I think the upper part is dark blue.
Yeah,
it's
just
a
to bring
blue, like a nautical.
that driveway
Yeah,
down
yeah.
there.
Yep.
I don't know how he's gonna be able to retain that, because that structure is right there, and that is way down there. That's part of the reason why I wanted to see that topo and proposed grades, because I just don't see how it's possible.
So let me ask a question here of all you guys that maybe have more experience than I do with this. To me, if I have this much put into a house design, a rendering like this, And, you know, this has got all kinds of implied construction detail to it. Wouldn't you have some sort of preliminary conference with the building department and the drain commission or whatever to make sure if you're gonna do any grading or things like that, that this is buildable? Or is that really?
Not if you're planning on getting this thing approved and then turn around and selling it. That'd be another potential.
No, I mean, he may not have any experience with this and maybe he
It
wouldn't.
sounds
do
like
it.
he's a builder.
Well, he said he's generaling his own.
What's he do?
He does something with GM, I believe.
Oh. Dear
Oh.
God.
GM guy.
He's probably teaches sensitivity training.
Remember, you're on video, buddy.
Sorry.
Oh, we are?
Oh, yeah, Ross.
You didn't tell me that.
No, I didn't, I meant to, actually, I apologize. Ross was informed that I don't know if this was specific to this meeting, but thought it might be a good idea, obviously it'll help with the minutes. We did at least preliminarily, it appears we've got consent that it won't go up on the website, right? So it will remain private, since we haven't all
So
consented to
don't pick
disclosure.
your nose and don't.
Damn.
Well, I would just suggest that if you're gonna insult anybody, be careful who it is, because they could always review the video and then you're in trouble. So, I mean, if I call you out, bleeping, you know, I mean, it's personal and it's on tape, or it's on bit by bit.
Damn, I'm gonna be fired and lose $80 a meeting.
You mean they
So
might?
look at that much?
You mean they might throw me off the planning commission and the board? Is that a possibility?
Yes, you're lucky, you finally found your way out. So here, let me say this quick before we move on. Thank you to all of you for the support here. This was a little bit tough. I talked to a couple of you prior to the meeting, but this was a little bit challenging, and I was trying to figure out how to referee this, because unfortunately, was it a week ago or 2 weeks ago? I'm losing time. It was
No,
2
weeks ago.
weeks ago. So 2 weeks ago, I happened to stop into the township hall to drop off some documents, and Mr. Bentley came in and was not pleased about our sightline requirements, and things got a little heated and personal. And so what I was really trying to do is keep him focused on, it's a planning commission, it's not me.
Somebody else other than you?
Well, and I also, even though it's wrong really for the chair not to be providing all the direction, I also wanted just a little bit of opportunity for others to kind of reinforce things so that it really, you know, wasn't all somehow misdirected at me. So, again, thank you, everybody. I mean, all your comments were perfectly appropriate and all that, and I appreciate you guys proactively stepping in and trying to help maintain order. So, again, thank you. So that said, let's pick a topic here and see if we can have a little more fun before we decide to bail and get out of here. So on the agenda, we have, let's pick one here, which I guess, here, I'm gonna let you guys pick, but if you let me, I'll tell you one I already started working on. So we've got proposed sign regulations, sightline regulations, which we may really wanna skip now that we've sightlined ourselves to death, and open space, which is the one I actually spent a little bit of time starting to preliminarily edit, if you guys are accommodating to that.
Okay with me.
Does that work for everybody?
That's fine.
Let's make it
Okay.
a sanctuary topic.
Yeah. Okay, so let me pull up what I did. So what I did was, I took the last version of Article 8, which the last time we updated this was March 6th of 2018, and that's when we actually did the open space changes, the requirements to open space, or eliminating open space. And then I've got Article 21, which this is really new, because this is what Terry had just sent me to do the updates to 21, 14, and 16 that were recently adopted. So this one I just need to get to 2152, or 2151, I'm sorry. There There we go. Okay, so let me, if you're agreeable, let me start with, Dave had a good suggestion, but I wanna try this from a flow point of view and see if he changes his mind, or he changes mine, or you guys all change my mind, or we all lose our minds. But I think the section we're really focused on right now is cluster development options, right? What have we learned in this whole process? And,
That our ordinance sucks.
well,
You're on
So-
video.
I don't care. So what I have been, again, carefully sharing here with communications back and forth to the county relative to Livingston County Planning Commission review of sanctuary is a question that Rob has asked me twice and asked again today, Rob Stanford at Livingston County, is what do we have historically that are substantially similar from a developmental point of view, so that he can compare what is being asked and what the planning commission is requiring, and see consistency, with prior applications and approvals. And what I had to tell him was, I said, in the 10+ years that I can recall at the moment, we've never seen a conditional rezoning, of course, because it didn't exist 10 years ago. Well, I guess it came in
2006.
Yeah, 2006, which I think we updated in 2007 or something like that. I don't know how proactive we were. But yeah, so it's been, but if I just go back 10+ years that I can immediately recall, we've never done a conditional rezoning, and we've never done a cluster development option, right? And so now we have an applicant that is trying to do both, right? Which is interesting, because the conflict that he's really creating for himself is that he is trying to go from FR to RE, and then RE to a cluster development, and now the problem is that he's gotten himself into a situation where the lot sizes he's proposing can't meet the district minimum standards, right? So they don't have enough lot width, they don't have enough rear yard setback, they don't have enough front yard setback, and then there's the open space aspect, right? And how that's being applied, and there's a few interesting sections in our existing ordinance that kind of clarify what we've all said, but they're not crystal clear. So let's talk a little bit about that. So in CDO, and what I did was I also have the other documents that were the updates to each of these the last time, if you want to see those. So it's very easy for me to pull up and show you what we changed in cluster development option last time, if you want to see that. Otherwise, this is all changes accepted as it exists in the current zoning ordinance, and all the edits that you see here are my first shot at just playing around and giving us something to talk about. So one of the things we've talked about, and Greg has mentioned when we talked a little bit about sanctuary, is PUD developments and applying cluster development option to PUDs. And so when this language existed previously, PUD district was right over there, Ron Gordon. That was zoned PUD. And since that time, we have removed PUD as a zoning district. We've implemented PUD as a planning process, right? So it's a tool to use, a methodology to actually plan. So one of the questions we have to answer is, for CDO, do we want to be able to apply that to a PUD development? Because it's not a district anymore, right? So we got to think through that. And initially I just corrected what would now be technically a typo, because we don't have PUD districts, we have PUD developments, right? Or we could have PUD developments, which the way we've currently got them architected, it would arguably be mixed uses only. So they're gonna be a mix of commercial and residential. So our thought process was, when we were talking sanctuary, is PUD would not be a good mechanism for them to utilize, because it's 100% single-family residential, no mixed use. So I believe right now, the way we have our PUD language written, because it's not a mixed use, then they can't utilize it. Greg, I think, offered that may not be the correct interpretation, but more importantly, I think what we need to determine is, what do we really want to do, right? And depending on what we want to do, we might want to clarify that language so that it's crystal clear, and somebody like me doesn't suggest it reads one way and somebody else says, no, Mark, you're wrong. So anyway, we gotta clarify that, but just for starters, I just kinda hit up that, hey, if you do cluster development in PUD, it's a PUD development. The other thing we kinda ran into is number of dwelling units, right, and how that's calculated. So when we get into the open space area, or was it down here further?
Keep going.
Yeah.
You went too far.
Okay, so it's actually in the open space section, which is referred to here, which is what I thought I recalled. So we actually have something in there that says for determining the open space requirement, literally what you do is take the land area of the parcel, and the number of units is determined by taking that land area and dividing it by the minimum allowed lot area, and there's your lot. So it is, these guys are suggesting, if you wanna look at the maximum, which there's the designation for me, it's not what you are permitted to do, it's the maximum. So they have 72 acres, right? So if it is 1 acre per parcel, they can develop 72 lots. We all know that they can't do that because nobody can take a 72 acre parcel and provide no access to the buildings within, which is, you're gonna have to do that to serve 72 homes, unless it's the weirdest, long and narrow strip of land where you can butt back and forth, front and rear
All
yards.
private driveways.
Yes, yep, one big long driveway or access road. But if you understand my point, the issue really is that you really don't take 50%, you really don't take the land area and divide it by the minimum required land area, and that's how many lots you're entitled to develop. The reality is we've talked about, is you should prepare a parallel plan, right? That says, I'm gonna take the land and I'm gonna develop it at the zoning district allowances that exist, and I'm gonna put my infrastructure in there, and that's gonna give me a plan. And then what PA 110 of 2006 says, the cluster development option, is you're entitled to develop that same number of units that would otherwise be allowed, which there's the clear words to me, and you're allowed to develop those on a smaller parcel of land, right? But that land cannot be less than 50% of the total land area, right? And your open space has to be not less than 50%, right? So this was just my first way of trying to clarify this, which I don't know if it's good language, but I just kind of tore out the old stuff that said, the total number of dwelling units permitted in the cluster development shall be determined by dividing the total land area of the subdivision by the minimum lot area required for the applicable zoning district before lot area modifications.
Okay, make sure your blue, which is basically a description of a parallel plan, matches parallel plan as we have it described in our definitions.
Thank you, that's a good point, and that needs to be looked at. So I was just freehanding this late this afternoon
It's fairly close to that from what I remember.
when I was bored, and I did look up some of it, as I recall, although it's blurry because I was burnt for the day and I decided to try to do something. So anyway, I'm thinking that we want to do something like, say, shall be determined by developing a parallel plan, which includes all required road infrastructure, regulated wetlands and woodlands, detention and retention ponds, sewage treatment areas, and any other infrastructure required by approving agencies. So that means you've got everything in there that's gonna take away your developable land area, if I can call it that, right? So the parallel plan shall then include the dwelling units that could be developed on the remaining land area, dimensioned to comply with the underlying zoning district. And then, as set forth in PA 110 of 2006, the resulting number of dwelling units can be developed on a smaller area of land, but not less than 50% of the land area that would otherwise be developed with dwelling units if CDO was not applied, which is what the Act says, right? So there may be a better way to word this, more clear, but I'm thinking we want to do something like that, that just in black and white says, hey, in case we're not all on the same page, this is what a CDO is, this is what the text says very clearly, which let me pull that up Dave, and that'll answer that other question. There's a nice document here that I can reference, that came in today. Where are you? Rob, it's Rob, right here. Okay, so this was the attachment I need to send you. So they submitted a document.
This is the same thing they sent us.
Maybe, but I'm losing my mind with all the documents anymore because I see about 1,300 of them now. So, I mean, and it's interesting what they highlighted and didn't highlight in a few sections, which when you see this again, it'll make sense to what I shared with you guys. Say again?
Who's this from?
So this is Boss. This is the information they submitted to the county to try to defend.
Dissuade what?
Yes, yeah. And again, and as we're talking about this, I'll share some of this with you guys now that I can, because context is important. So again, they did cite the right sections here to some degree. This is also mixed with different versions of zoning ordinances, and it's a mess from my point of view. And I did not copy you for obvious reasons. I will copy you, but some of this actually on this
He's
stuff, I think
already got it.
this stuff I did copy.
I got a few of these things.
Yeah, these things I did copy you on, yes. So, again, it's, shall provide in the zoning ordinance, land zoned for residents may be developed at the option of the landowner with the same number of dwelling units on a smaller portion of land than specified in the zoning ordinance, but not more than 50% for a county or township, that could otherwise be developed. So that to me is the key wording there, because nothing in there says, oh, I'm entitled to the maximum number of lots if I do simple math, because you can't develop the land that way, right? You have to have infrastructure, and without that, you can't develop it. So the otherwise could be developed is, well, I couldn't develop it without infrastructure before, how could I develop it with infrastructure now?
That's why when I made that motion, I didn't include anything else other than the act.
I understand.
Because the ordinance was wrong.
I think all of us understand that, and that's why I've been trying to make points. I've focused on the fact that it doesn't matter that our ordinance is wrong in a couple areas that are not clear or not properly updated, because as you have stated and others have stated, all that matters is, in this particular case, is our ordinance is trumped it's usurped by PA 110 of 2006 in this area. Here are the CDO requirements, right? So here's the minimum. You gotta meet this. So the fact that our ordinance has a couple of interesting, when you go through it, interesting slips here and there, or omissions, or whatever, which everybody's does, it's just kind of interesting. But again, I'm gonna go all over the place here, but I'll show you a couple of things that I just thought were interesting. So, they make references to PA 110, which is fine, the density aspect, which I misread for them. What they say is not worded the way I would word it, but the project does comply. So here's undeveloped state 110 definitions, and there's a couple of interesting things that they had stated or provided. So undeveloped state means a natural state, and for some reason they didn't highlight the other key elements. They acknowledge that most of our stuff we have is copied from PA 110, which is what we intended. I'm scrolling real fast. I'll forward this to the rest of you guys so you have all this. If you don't already have it, I guess you're thinking we already saw this. Definitions, though, I thought this is where they were trying to earn points, and this is where I thought they kind of sunk their own ship when you go back and reread this. Lot area developable. The net lot area not intended to be included as open space as described in section 2151 of the township zoning ordinance. Okay. So then what that means is your 1.0 acre lots that you've proposed, which you're advertising as 1 acre, they're not really 1 acre lots, right? Because you can't include the open space. So now they not only...
The net lot area not intended to be included as open space.
But that's the lot area developable, right? So the
Yeah,
developable lot is the area of the lot that you then dimension and put your building envelope in, right? So if their building envelope goes up to the rear yard setback as they currently have it, and they make that all open space, right? Then the building envelope they have doesn't represent the developable lot area because they don't have a rear yard setback.
Yeah, I agree.
It's like, okay, thank you for that, that helps.
I agree with that, but the one thing I've noticed over the years is that lot area developable
Yeah.
doesn't exist anywhere else in the
Right,
code.
that's what I was
Yeah, it's
saying,
like,
it's
what
a
the hell is it?
definition that isn't used
Well,
anywhere.
and so maybe we need to utilize that or clarify
But
that.
it does point to the truth of what we observed for a while,
Right. Yeah.
which is that their lots aren't really 1 acre lots.
They're .75 at best.
Okay, so open space once required has to comply with 2151. Now, the maintenance agreement, this I thought was rather interesting. So, you know, they're making note that there's a maintenance agreement that's required. Yep, thank you, appreciate that. So here's where it gets kind of interesting. So very specifically, open space says exclusions, open space shall not include certain easements, areas devoted to public or private streets, or the easement for shared driveway or public roads. Yeah, we know that, there's 6 acres of private roads in there, you can't include that. But for some reason you think you can, or you seem to be with the math, okay?
Well, I don't think he was including the public road or private road in the open space.
He's trying to offset that, but he can't, right? Because 36 times 1 is 36, plus 6 is 42, and you really can't get 6 acres by taking the rear yards out of 36.
No, I agree.
It just, yeah, it's just, so here's where I've been kind of hammering the point back and forth with the county is, so, and there's a spot down here I'll show you. I mean, unfortunately, what Dan is doing is he's effectively telling the county that the township is required to allow them to provide, to use rear yards as open space because they otherwise cannot meet the cluster development requirements of PA 110, and we are required to allow them to use that area as open space so that the development complies. It's like, whoa, 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 the burden's on you, not on the township.
I still maintain that that he is preserving that open space so that the intent of preserving the open space for him was to meet the CDO requirements of having it,
Right.
and not to preserve the open space.
Agreed.
That was,
Absolutely.
yeah, that was the point I
Right.
think I was trying to make.
So the problem to me, where they're really gonna fall short on this, in my view, especially if this ends up going to court, is for some reason, the yard setback exceptions that we have listed, they're at the planning commission's discretion, right? And the applicant is saying that they are requirements that the planning commission must follow to the benefit of the developer. So the planning commission may allow specified areas located within required yard setbacks. Doesn't say it has to, right? And then it says individual parcel, which this needs to be updated, which I have in the other text, which is why I'm going through this. When this existed, this open space definition was for land divisions, right?
'Cause it's
So
all
it
singular.
references, yep, it references a parcel, and what it really needs to say is an individual lot, parcel, or condominium unit, right, to update it.
Is he doing this as a condo?
Yes, it is a site condo. The other thing that is interesting too is relocation. Open space may be relocated if the planning commission and township board find that the original intent of the open space requirement may be met at another location with a lot, parcel, or condominium unit. This does not say that you can take all the open space required in the development and relocate it to all of the rear yards in said development. It also doesn't say it's required, right? What it says, and the intent of this originally was, you've got open space on a parcel and, or a lot or whatever, within a condominium unit. You may wanna take that and move it slightly opposed to what the ordinance says is the ideal location, right? Cause it may actually, there may be a spot on that developable lot that actually has woodlands, wetlands, or something you wanna preserve, or topography. And so we've said, yeah, you can, we had a provision to relocate, and we did that in a few developments.
Once again, it was singular.
Yeah. Now here was the other kicker that I thought, that I found, and this is why I'm sharing it, and I'll go back to the original topic here. But so they cited, and this is not the right numbering in our current zoning ordinance. This is an older version of the zoning ordinance, so this 9 is actually a letter instead of a number. But these are requirements for establishing a maintenance agreement for the open space. Now, they highlighted the important section, which is one of the things I originally missed. If open space is not dedicated to public use, so rear yard setbacks, it shall be protected by an open space maintenance agreement as described herein. Our argument, at least some of us, our argument and concern was, well, what's to prevent the site condominium owners from amending their master deed or bylaws and doing whatever they want with it at some point, therefore it's not preserved in perpetuity. Well, look at what one of our provisions is here. If open space is not dedicated to a public use, in other words, it's in the rear yard setback of the lots, they can, the open space maintenance agreement shall address removal of vegetation. It shall provide for removal of dead and diseased vegetation if applicable. Oops, I think we just disturbed our undisturbable open space. It's supposed to be preserved in perpetuity. And do we really think that Ross or anybody else is going to go out and decide and determine what is dead and diseased? And once it's removed, how do you know? Who's gonna police that?
I still say this maintenance agreement was part of the individual lot split, and that's why we need to get rid of this portion of it
Well, or amend
altogether,
it,
because
or
we don't
amend
use
it.
it.
Yeah, or somehow consolidate, amend. So, I said all that to share, but also to get back to, so we got number of dwelling units, we need to clarify that. And then the other stuff here that's left over in the cluster development option, I think we want to clarify. So there's an interesting section in here, the way it's titled, it says modification of requirements, modification of lot area, width, and yard setback requirements. Item 1 very specifically refers to this table that says here's the reduction in the lot area that can be applied to the various zoning districts if you do CDO. There's not a comment anywhere about modification of lot width or yard setback
And
requirements.
I wanted to ask Greg that question. I looked through a whole bunch of different ordinances. One of them that I found, I believe, is Commerce Township. They have a CDO ordinance or CDO section in their ordinance. And they specifically have a table similar to this, but they also modify yard setbacks. Is that something we're allowed to do under a CDO? Because they're specifically doing it in theirs. Which, quite frankly, I would anticipate that if you're gonna do a CDO and you're gonna reduce the lot sizes, you're gonna reduce the setbacks as well.
Well, so here's why that question is important. So the way the act reads is it pretty much says that you must, the development must comply, where's the words actually?
With the underlying something.
Well, the words we use, it must comply with the underlying zoning district requirements, but what the act really says, actually that was in this page, but it says something to the effect of that it still has to follow all rules, regulations, and laws applicable to the municipality or township or something like that. It uses some words like that. So what it gets back to is, I think the question we need to try to get an answer for is, are we allowed to modify the dimensional requirements for the district? And if you do, then in a case like this where you've conditionally rezoned, so you go from FR to RE and CDO, and then if you modify those dimensional requirements, it's not RE anymore. But then if it's a conditional rezoning, one might argue that those are concessions, those are conditions that should then come with offsetting concessions that maybe you could accommodate in some way, shape, or form.
Well,
That was the other thing.
my sense of it would be that it's the opposite of that you can't make it, as I said before, you can't make modifications as part of a conditional rezoning, because the zoning district that you're conditionally rezoning to isn't being changed. You're just limiting what can be done there to a subset of what can happen in that zoning district. my sense is, without having researched it, is that you could modify setbacks as part of a cluster development option. You know, just like you're modifying lot sizes, you know, how is it any different? Well, those lot sizes aren't allowed in, you know, whatever zoning district you're applying the cluster development option to. You're, by virtue of allowing that, that form of development, you're modifying lot sizes. Similarly, you can modify setbacks, I think. And you almost have to make the lot sizes work.
Right, so let me make sure I captured what you said. So if I apply CDO, I need to comply with the underlying zoning districts. If I do conditional rezoning, maybe I can modify
No,
some of
no,
those. That's
no.
not what you said.
The opposite of that.
You said the opposite of that.
So if all they did is come in and say, we're asking to rezone to RE, but we'll limit ourselves to single-family homes, right?
Mhm.
None of the other things that you can do in RE.
Mhm.
There aren't that many other things, but there are other things.
Mhm.
So, or we're limiting ourselves to 5 single-family homes, or 36, as the case may be. That would be appropriate use of a conditional rezone. If you wanna come in with conditional rezoning and say, we wanna conditionally rezone to RE, but instead of 1 acre lots, we want half acre lots, no, you can't do that. That's not that's not an aspect of the RE district that you can choose to condition your proposal on. However, cluster development is intended to work as a modification, not dissimilar to a planned unit development, as a modification of the existing district requirements. You know, by its nature, it does that.
Mhm.
It limits, it allows for smaller lots than what otherwise would be allowed. And so, in the same way, my sense would be you could allow for other dimensional modifications consistent with that. You know, so if the normal setback is 50 feet, you know, for the CDO option, you could allow 25 feet, or 35 feet, or whatever it is, that allows those smaller lots to be functional.
See, I think, and I'm following you, and I'm not disagreeing with you. I think that the conflict with the current situation with sanctuary is really kind of a self-created conflict, right? Because if he just came in and said, I wanna do CDO, right? You could do that. And you'd probably be fine if you applied CDO the way CDO is intended to be applied, and you could meet your dimensional requirements once you properly laid out your development. The problem in this case is you're going with you're in an FR, and you want to choose the minimum size lot possible, right? And then you want to rezone it to RE, and you want to use the minimum lot size possible in RE. Then you want to apply CDO, and so now what you've done is you've just continually, exponentially almost shrunk the available land area for a number of lots. And then of course the real kicker in this particular case is just the suggestion that he's entitled to 100% utilization of the land area for lots prior to putting in infrastructure, right? So as soon as you do that, all that land area that's the required infrastructure basically is offsetting the available land area that could meet the dimensional requirements for the underlying district.
Yeah, as your ordinance is structured, there's no way to max out, to equate your density to, in the cluster development option, to what you maximally could have based on the reduced lot area for the reason that you said. You also have to have roads, and you also, as a condition of doing a cluster development option, have to leave 50% of land
Right.
in its undeveloped state. So as soon as you leave 50% of it in its undeveloped state, the other 50% can't handle the entire density that would have been permitted just based on lot area calculations on the entire parcel, because as you point out with your parallel plan proposal, you know, a parallel plan would not have contained that many units on the entire parcel.
Yeah.
Because infrastructure would be required there as well.
Right. Okay, so I guess something for us to have Greg help us follow up on is maybe do a little research and see if you can reasonably conclude that we could, under the act, modify underlying zoning district dimensional requirements.
Okay.
I'll send you the one I found. It's not on this tablet for whatever reason, and it wasn't Commerce. Commerce is the one that actually has a list of suggested conditional rezoning things that they're going to, that they will accept.
That will modify, yeah.
Although you have to voluntarily do it, but you will accept these.
I'm not here to argue that places don't do exactly that, because they do.
Oh yeah, Commerce Township's one of them.
And, well, West Bloomfield was another one, until, at least until I got there. I may or may not have fixed it during my 6-month tenure there, but they certainly tried before that.
Gotcha, interesting. All right, so we'll follow up on that. So the other thing that we kind of learned the hard way in this particular case is, so under 8.03 open space preservation design standards, we probably want to add something to the effect of required rear yard setbacks shall not be used to meet the minimum open space preservation requirements, but may otherwise be designated as open space if desired, right? So you can designate them as open space, but you can't use that to meet the minimum open space requirement.
Go one step further.
Absolutely, this is, I just
Rather
started
than
typing
like-
to get us
and
started.
I don't know how to say this, but rather than saying required yard setbacks, open space shall not be contained within lots, period, unless so desired.
And we can do that.
I would hope you put it a little bit more appropriately than that, but.
Because there's no way to enforce that after, you know, after it's granted, that's a giveaway.
Right. Lot areas,
Or condo units.
yeah, lot or unit areas.
So we'll do this the way it's set forth as. Something like that.
Yeah,
Unless parcels.
unless desired.
Unless desired.
No, but.
That doesn't make any sense. So you can't do it, but you can.
No, but then the
Unless
same
you want
statement.
If you want to.
The
You can't
statement
do it, but you
got-
can if you want to.
Yeah, the statement you got at the end of the first one, but may be otherwise designated as open space as desired.
Okay.
So,
Should be included
To
within
meet the
required,
minimum
yeah,
open
yeah,
space.
got it. Yeah, so I kinda said that same thing, but I said it with a slightly different intent, yeah. Okay, so,
no, we still don't have it.
open space shall not be included within the required lot, parcel, or common areas, but may otherwise be
No.
designated. Okay, so what?
Up to the top, you got required yards setbacks shall not be used to meet the minimum open space preservation requirements.
Yep.
That shall not be used to meet the minimum open space requirements. Should be after, condominium unit areas, that insert that part of the sentence.
I'm not following you
Okay,
at all.
take, required yard setbacks shall not be, grab it right there from shall not
Got
be,
it.
all the way down to the comma,
Okay,
and then put the right, some kind of areas, right in between there, but
We've got two shall nots in this.
that's okay, we'll fix that.
I think.
It's draft, shall
Well,
not,
no,
we
no.
shall not,
Open
okay?
space shall not be included within the required lot, parcel, or condominium unit areas. That's shall not be.
Yeah, so something, we gotta work on it,
Yeah.
but we'll figure it out.
Strike out the word Go
Let's see
down,
this one right
yeah.
here?
right there to the word, condominium unit. Go down to the word used. Keep going. Four more.
Oh, this one here,
Yep.
got it?
Delete that. Or condominium unit to meet the minimum open space preservation requirements, but otherwise may be designated as open space if desired.
Okay, so you're saying, so this is what you're proposing?
Yes.
And this goes away?
Yes.
Okay, so let's take a look at that. Open space shall not be included. So is it open space or required open space? I think it'd be required open space, right?
Well, we've got it later on where it says meet the minimum open space preservation requirements.
Yeah, okay, all right. Yep. It's just all semantics and how you want to word it. Open space shall not be included within the required lot parcel or condominium unit to meet the minimum open space preservation requirements, but may otherwise be designated as open space if desired. Yeah, that works.
Or something similar.
Yeah. I like that version. Okay. And then
You guys look all real official, sitting behind all this.
we're darn official.
We also look very short.
Yeah.
I noticed that walking in, because you really, all you see is like, you're up.
We're all standing on our,
Old Kilroy's.
we're on 3-foot platforms and you can't tell, we're all little gnomes or something, yeah. Okay, so I think that's a good start there, and then just to review this other part quick so we can get out of here as far as we're gonna get. So Dave has suggested maybe taking open space and consolidating it in with section 8, so it's all in one location. And I'm not sure I'm 100% convinced of that yet, but clearly there's text modifications. We can figure out how to reorganize this, which that still may be the best idea. So I just started pouring through this looking for, again, lessons learned. So if I just scroll through 2115-1 really quickly, we've got yards, parking lot services, blah, blah, blah. So yard setback exceptions. So consistent with the conversation that led us here, which is why I shared some of the boss engineering stuff. So I kind of proposed amending this where we would, the planning commission may allow specified areas located within the required yard setback or setbacks of an individual lot, parcel, or condominium unit, so get rid of parcel, to be included as required open space if the commission finds that the protection of that open space area is consistent with the intent of the open space concept. Propose adding this exception shall not purport to permit required open space to be designated on most or all lots, parcels, or condominium units within a development. So just kind of a clarification that, we are saying you can do this on an individual lot, parcel, or condominium, but we're not suggesting or saying that you can do this to all 36 units in a 36-unit development.
Well, what kind of land within an individual condominium unit, lot, or parcel would be worthy of that designation?
What if a portion of the property is a swamp, pond, something of that nature?
In which case it wouldn't be considered open
Yeah.
space because it's wetland.
If it's a slope.
Well, but you can use not more than 35% of the minimum open space areas used to satisfy can be open wetlands.
Correct. Yep, that's F here.
And so you can use another 20, does that mean you can use 25 and 35 together using the submerged
Yeah,
land? So you could add, those are additive.
that's my understanding. When we went through, I think there was one application we did years ago, and we did discuss that and we did allow that, because it's what it really, it doesn't say it's one or the other.
So 60% of it can be swamp, or swamp and pond.
Yeah,
Mhm.
Okay.
so if you had, and again, we just gotta think that through if that makes sense, but I mean, a good example of this might actually be the Goodfellow Lake area there, so that area north of White Lake Road.
Yeah.
And think about a development there with a couple of proposals that have been laid out, and you sit there and say, what is that land? It literally is 60+% wetlands and water, right? So a lake. And so if you begin to think about that, how would you reasonably develop that property if you couldn't include any of that as open space? And how would you preserve it? And I'm not saying there's not an answer to that, but just, I think that's what we gotta think through, because if you
But
have.
in that case, 60% of the 50%
Mhm.
can be made up of unbuildable land that's swamp, for the sake of swamp and pond.
Yeah, but you're back to, we just need to decide, is that really our developmental intent to protect and preserve that as undisturbed open space? And one might argue, yeah, that's what you really wanna do with that land, right? Maybe the quantities aren't right, maybe there's exceptions, but I can, at least in that application, I can foresee where that might be a good thing to allow. Because then you can reasonably develop the remainder of the property. Otherwise, you keep shrinking that development to the extent where, you know, your 72 units, which are really only 36, which are then burdened by 50% stuff, which gets you down to somewhere between 16 and 22, is further reduced to 15, and nobody's ever gonna be able to build there, right?
Okay.
I mean, just a good scenario to think through and kind of see what works or doesn't.
I don't want to see, just saying.
Oh, that's okay.
Well, all boss needed to do was add those 2 lots that all he could raise is mosquitoes on. That
Right,
anyway.
Yeah, well, that.
And he still wouldn't have made it, but we would have.
Right.
It would have been
It
close.
would've been pretty darn close, yeah.
And D, I mean, if we're gonna keep C, we gotta do something with D, because I don't know what the hell that's trying to say.
I do.
I'm glad you could figure it out, because I don't have a clue.
So when we applied this before, and this is, yeah, I did reread this a couple times too when I was looking at this. But, so I'm drawing a square here. So here's your lot.
It looks like a parallelogram, just saying.
Quadrilateral.
There you go. Tetrahedron?
It's a sloppy square.
Alright.
Okay, so your open space is in the perimeter. So it's along the outside boundary. So if you know, this is open space, or somewhere all of that is open space, that's open space located within the perimeter.
So your setback is from that, not from the property line, is that what D is
Well,
saying?
the part I don't understand is the setback shall be measured from the closest point of the open space boundary. Closest point to what?
Where the building's gonna go.
So
On
this
which
is,
side?
this is, this is,
But the inside, I don't know.
as I recall, the only application, if I recall correctly, and I'm not gonna claim that I do, but I seem to recall we had one application of this, and the reason why this language was kind of weird like this was because the boundary was irregular in shape. So it had,
Zigs and zags.
yes, not exactly to that extreme, but there were some dimensional anomalies. And so it kind of got back to, okay, why can't I use that as open space? And I could, but if I do that, then I gotta start my setbacks from that boundary, right? Which, again, is another example relative to, unfortunately, what the Boss development doesn't do, is they're saying they're gonna use the perimeter, the entire rear yard, right, as a required rear yard setback, but then they have the building envelope abutting the open space, right? So the setback isn't properly applied there. There still needs to be a setback, so the building envelopes are wrong, right?
Was that, yeah, interesting.
So that was an interesting find or realization that I had as well. But yeah, so you don't like C, and that's absolutely okay. So what I've just tried to do is, yeah.
It's not
So by not,
specified areas,
yeah,
and I'm just gonna be
Yep.
argumentative because I always am.
good.
Define specified areas,
Mhm.
because what I would be concerned about is at some point in the future, it probably won't be us,
Mhm.
God, I hope it's not us, but it could be the next planning commission or something else. Somebody like Boss comes along with a sanctuary thing and they say, hey, look, these rear yard setbacks, they're specified areas and we think you should allow, save them. And there's nothing in there that says that we can't.
So you know how I think by now. So what
Yes, and it scares the shit out of me.
there you go.
Just saying.
Congratulations. Thanks for joining the popularity club there. So it is just a starter of conversation. It's like, here's what we have, here's the defects we've identified, or the flaws or things we might want to modify. So there's nothing that prevents us from completely either eliminating or rewording that whole thing once we decide if something regarding yard setback exceptions is even a necessary topic.
No, I get that, I'm
Yeah.
just voicing my opinion
I like it.
as frequently as I can.
Yeah, so if we removed it, would they still have an avenue to propose it or to get something approved if it's
Well,
not in
so I would just suggest, don't think of they, as much as there's an application right now that's
No, no, I'm just saying,
identified,
and anybody, and on that specific.
Right, I think my advice would be when we think about things like this, and especially in the context right now of, I wanna redo this, is in your mind, try to envision why a standard like this might exist and how you might apply it. Not that you would apply it regularly, but try to almost come up with an exception in your mind of, hey, I need a tool to deal with this rather unique situation, and is this a tool, or if I eliminate it, do I eliminate a tool I might need, right? So you've got common standards, and then to me, when you're doing, especially things like exceptions, what you're looking for is that, hopefully, 1 in 100 or something like that situation where, hey, I ran into this once, or I thought about this, and that could occur, so I know I need to deal with it, and here's a way I could deal with it, right?
See, I look at it differently.
Of course you do.
I look at it from the standpoint of a developer, how can I cheat this ordinance?
Which is perfect, because that is
And
exactly.
Try to eliminate the cheats.
So that is the other perspective we need, right? Because as much as you can provide,
Like whack-a-mole.
yeah, as much as you can have a provision to help somebody, those provisions, especially when they're intended to help somebody, they often create loopholes
They'll be
that will hurt you.
exploited, yeah,
Yes,
for
exactly.
Yeah, to me, this feels like it's more geared towards when our ordinance said, hey, you can have 3 acres, but one of them has to be.
That's
Yeah,
correct.
that-
And it
that's
is,
exactly where it came
Now
from.
it's
Yep.
different, so
Right.
it
That's
feels
correct.
like it could be
Yep.
removed, but you're right, it is the potential for.
so to all of your points, I mean, the thing we have to do is, we gotta work through this list and say, what is still applicable? Are any of these applicable for people that have historic open space that might somehow still apply, right? Which the answer for that ought to be limited. And then, once we whittle that list down, do we still wanna have an open space section that we refer to, or do we consolidate all this up into section 8, or article 8 with the other open space preservation stuff? In other words, is there a need to discuss open space outside of open space preservation anymore? I think the answer is yes, because at the very least, we require it for commercial developments. We do require open space still for those developments.
Well, we can fix that.
Sure we could. But I mean, you're just back to, if we're gonna still do that, then this probably needs to reside out here to some degree, or some text needs to reside outside of Article 8. All right, so let me see if I have anything else here, just as thought starters for everybody. And I did this at 4:30 and 5 o'clock today, so I didn't send this to anybody, I literally did it in. So like for vegetation, just thinking about that text that I found and mentioned earlier, so maybe we should say that your maintenance agreement needs to provide for or prohibit removal of dead or diseased vegetation. Who says that you're permitted to do anything with any of it, right? But you certainly, as part of a maintenance agreement, you could accommodate either one, and that would cover the loophole, right?
Depending on what the situation is.
Yeah.
Yes.
Yeah. And then the other thought I had, crap.
Or should we add another one that says preservation of vegetation?
Yeah,
Cause that's right there, it says removal of vegetation.
right.
Or, another line altogether that says, but I'm just, preservation of natural features or.
God dang it. Fingers.
And same language, but.
So we can develop something for that, that's a possibility, so we'll talk about that a little more. So the other one that I picked out here was, again, this perpetual open space stuff. So what's one of the weaknesses we identified is condominium units, the ability to amend master deeds and bylaws. So I was thinking perhaps maybe what we do is, even though there's some language in here that implies legal instruments such as deed restrictions, homeowners association bylaws, or other similar devices shall be used to assure continued maintenance of the open space and to guarantee the open space shall be used only for open space purposes in perpetuity. Well, so we still haven't really defined what all that is, and it needs to be defined, but that simple statement of using homeowners association bylaws, those can be amended, right? So there's nothing that says they're not amended without the township knowing, even though if there's a maintenance agreement the township approved as a condition, right, for whatever. So maybe we need to add something like where a master deed and or bylaws provide the terms and conditions for open space preservation, no modification to the open space maintenance provisions and requirements within these documents shall be no open space maintenance provisions and requirements within these documents shall be modified without consent of the township board.
Springfield Township does that a lot in their, community septic system. They will go through each master deed and they will figure out which sections in the master deed they want to have a say over it. And they will put a statement in there like that, and they will specifically mention each section. So that if anybody pulls, and then it's duplicated again in that section.
Yeah, and so then that should be included in the site plan for the condominium, right, and therefore
That's part of the master deed.
Yeah, got it.
So nobody's gonna change it without knowing that they're violating the law if they don't contact the
Yeah.
township.
So again, not saying this is what we have to do, just getting some thought starters here of things that I think we've identified from the last one. Let's see if there was anything else in here really quick and we'll get out of here. I think that was basically it, as far as I got to. Yep, so 252, so that gets us to there. So some thought starters, I'll send this to everybody, okay? But just kind of begin to think a little bit about open space and the things that you've experienced so far, and see what loopholes or things you can identify, either stuff that we don't need anymore or loopholes that we've kind of encountered, and then we can kind of begin to tailor what the new open space requirements are and go from there. Make sense? All right, so let's now talk about signs. I think we got another half hour we can work through. I'm kidding, of course.
Motion to adjourn?
Support. Yeah, so the only other thing I had, which I'll just throw up here so it's in front of your eyeballs for those of you that can still see at this late hour. So next Wednesday, which is would be our normal workshop meeting night, that is the Livingston County Planning Commission night with Boss Engineering.
Oh, boy.
So
Gonna attend that one, are you?
even though I don't really think I want to get heckled in the crowd, I think and it would be nice if somebody else was there as well, if you guys want to go. So I'm going to suggest if Ross is able to verify room availability, which here, there's plenty of rooms available.
Yeah.
Always, if you guys are agreeable, we could defer to Thursday, the 20th at 6 p.m. for a workshop, and then we could focus on, we could do either signs, open space, or we can just pick the agenda items we had here. So we got signs, sight lines, and open space. We got plenty of stuff to work on.
I'd like to get the signs back to the board
Yeah.
so we can get that done.
And I need to, what was I thinking about here? So I need to get a formal letter from Greg Carnes, just regarding the nonconformities. I wanna just make sure that's on the record with all the boards so they know that's not hearsay from me. That says that the ZBA wants to retain, like we talked about, and see if we can get them to buy into that. I mean, the other thing is I might want to have you refresh me with a couple words you had where you made some comment to the effect of those things that are variants, like you've not seen planning commissions or administrative approval, those things in other communities. It's typically ZBA. So I might want a statement from you as well, just to kind of support what we're doing is consistent with sound planning. I'll let you know.
Okay.
Okay.
Next Thursday, I think I have a conflict.
Okay. Yeah, and that one's, I mean, as much as it's good to have you at those, it's not required, obviously. We just need to keep you in the loop so you know what we're doing periodically or what we're thinking, so you can go, you guys aren't thinking real straight on that particular subject.
You have to be able to think like you think, right? Unless I've been indoctrinated into it.
Oh, come on. You're similar. All right, so we'll plan on workshop and we'll do signs. See if we can't just beat that out. We only got 2 hours max, so that we'll just say that singular topic, and if we somehow get through it in 10 minutes, maybe we'll talk about one of the other ones.
Yeah, so I don't think there's a whole lot of things that need to change. I
Agreed.
think
Shouldn't be for signs.
Mike just
Yeah.
got through that, so.
Yeah, you had indicated as same, so let's see, I want to save this, and I don't, yeah, I fixed that Okay. So we'll say 6 PM, and then if anybody wants to go to the Livingston County Planning Commission meeting, I'm not suggesting you have to. You know, they do like attendance, as Rob said. But if you're interested, I believe it's 6:30 PM. And I'll send you guys I'll send you the location and all that. I'll try to explain it, but I mean, if
You're asking me, do I wanna go to the dentist's
Yeah.
office tomorrow?
yeah,
Not that I have to.
exactly. Okay, we're adjourned. Thanks, everybody.
So they went to Livingston County.
Appealing to them?
No, so the statutory process for zoning amendments and things like that is a Livingston County, it's county, it's not Livingston County. The county is required to, they're given a 45-day period to provide on the comment and recommendation.
A lot of counties have eliminated this.
Now, it's not binding,
By
but they
statute,
are, and it's a little more, so it's implied that it should be done, and it's kind of optional, but the county does it for zoning amendments. Conditional rezoning, the statutory thing says, the way I read it, is they must.
Yeah.
I see, so they're